Amy, can you hear me?
Yes. You hear me?
Are you ready?
Are we ready?
We're ready. Are you?
I think so. Yes.
All right. We do have a member that will be arriving shortly, but and she will be on Zoom, so we may have to
Yes.
stop for a minute to let her
Yes.
on. But we are going to begin because we need to get going. So I will call the State Board of Elections in order, and for January 8th at 9 a.m. And if you will all stand, please, for the pledge of allegiance. I pledge allegiance
Allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
All right, thank you. If I could, I would ask for a motion to recess the state. Sorry, Amy. Always forget. All right, roll call, Amy.
Ms. Bellercroft,
Present.
Ms. Cray,
Present. Minutes.
Ms. Genovese, Ms. McCory,
Present.
Mr. Brett, Ms. Watson, Vice Chair Turvin,
Here.
Chair Donahue.
Here. All right, can I have a motion for the approval of the minutes of November 18th and December 9th, 2025, for their approval, please? So moved.
Second.
It's been moved and seconded. Amy, roll call, please.
Ms. Bellercroft,
Yes.
Ms. Cray,
Yes.
Ms. Genovese,
Yes.
Ms. McCory,
Yes.
Mr. Brett,
Yes.
Ms. Watson,
Yes.
Vice Chair Turvin,
Yes.
Chair Donahue.
Yes.
Motion passes.
Now, can I have a roll call to recess the State Board of Elections and reconvene as the State Officers Electoral Board? So moved. Second. Been moved and seconded. Can we roll call, please?
Ms. Bellercroft,
Yes.
Ms. Cray,
Yes.
Ms. Genovese,
Yes.
Ms. McCory,
Yes.
Mr. Brett,
Yes.
Ms. Watson,
Yes.
Vice Chair Turvin,
Yes.
Chair Donahue.
Yes.
Motion passes.
Thank you. All right, we are now sitting as the State Board electoral officers, and we need a roll call for that, don't we? Roll calling.
Ms. Bellercroft,
Present.
Ms. Cray,
Present.
Ms. Genovese,
Yes.
Ms. McCory,
Present.
Mr. Brett, Ms. Watson, Vice Chair Turvin,
Yes.
Chair Donahue.
Present. All right. Now we can dig. Marnie, if you would like to begin, I think we're going to take 550, SBOE 550.
We will. First, I wanted to give a little introduction to anyone who wasn't here yesterday.
Perfect.
So to anyone who was here yesterday, thank you for the 4.5 hours of listening to me talk. And we're going to do it again, but hopefully shorter this time. So I'm Marnie Malowitz. I'm the general counsel of the board. And today the board will be hearing objections to the nomination papers of candidates seeking to appear on the general primary ballot in March as established party candidates. For each case called, I will read a brief summary of the objection, the recommendation of the hearing officer, my recommendation on the disposition of the case, and any exceptions that were filed by the parties. Objectors will then have no more than 3 minutes to make oral arguments to the board, followed by candidates who will have no more than 3 minutes. Staff will be using a stopwatch to ensure arguments stay within the time limit. So the chair right over here will let you know when you're at your time. The board may grant you more time for argument if they wish, but under Rule 11, they have the ultimate authority to decide what oral arguments may proceed, not me. The board has 9 cases to hear today because we had one continued over from yesterday. The parties have already been given an opportunity to present evidence and arguments to their hearing officer in all of today's cases. The board has copies of the objections, the dispositive motions and briefs, the hearing officer recommendations, and any exceptions. So there's no need to reiterate all of your arguments that your side has advanced. But please remember that no new evidence is to be presented here today. And if you try, I will cut you off. This is an opportunity to make legal arguments and explain your position to the board. Please also keep your voice as loud as possible so the folks in Springfield can hear you. In Chicago today, to show you where to stand when you're speaking, there's a little white sheet of paper on the ground. So it's not the easiest thing to see, but I'm sure once people start doing it, it'll start to make some sense. Also, before you speak, please make sure that you state and spell your name for the court reporter to keep a clear record. So once the board has voted on your case, it will take a few minutes for board staff to prepare your board order. But then you can pick up a copy of the board order from our legal counsel to Sean Sarku, who's over there in the corner in Chicago, or from Jordan Andrew, our deputy general counsel, who is down in Springfield and who is hopefully raising her hand right now. Once you have your order, if you have other matters before the board, you can feel free to leave if you prefer, or you can stay for all of the hours that we are here in the regular board meeting. So I want to thank the board staff again, and especially the legal staff, all the effort you put into our 80 electoral board matters this year. It's been a big one. So this is great that it's coming to a culmination. And with that, we're going to call a couple of cases out of order to accommodate people's court schedules today. So I'm going to start with agenda item 1H. That is Ortiz versus Aquino, 25 SOEB GP 550. And if council would like to stand over near that white piece of paper, I will read my recommendation. So objector Ortiz, who is represented by attorney Perry Abbasi, objected to the nomination papers of candidate Aquino, who seeks to run for Democratic State Central Committee person in the 3rd District. The candidate is represented by attorney Adam Butt. The objection petition makes individual signature line objections and claims that there's insufficient signatures after those individual signature line objections. Claims that the petition sheets are invalid because the purported circulator did not reside at the address declared by the circulator. And finally, that the circulators and notaries engaged in a pattern of fraud. A records examination was held in this matter, which found that candidates submitted 116 valid signatures, which is 16 above the statutory minimum of 100 signatures per section 7-10F of the election code. The objector timely filed a Rule 9 motion on November 26, 2025, which was the final day of the 3-day Rule 9 motion period and therefore the deadline. Candidate filed a Rule 9 motion, but not until December 5th, 2025. So the hearing officer recommends finding the Rule 9 motion untimely without good cause shown. As at the hearing, the candidate was given an opportunity to show good cause for his failure to timely file the Rule 9 motion. And in response, candidate's counsel indicated the candidate had not known which signatures would be challenged by objector's handwriting expert and what objector's evidence would be. I agree with the hearing officer's assessment that this is not good cause for filing a Rule 9 motion 9 days after the deadline. During the Rule 9 hearing on objector's Rule 9 motion, the hearing officer struck 10 additional signatures based on unrebutted expert testimony and struck an additional 12 signatures based on unrebutted affidavits of signers swearing they did not sign the candidate's petition. Candidate's Rule 9 evidence consisting of 12 affidavits were admitted provisionally subject to the timeliness issue, though the affidavit of Lillian Torres, Lillian, Torres, Torres, was not considered because it was incomplete and did not identify the page and line numbers of her signature on the petition. Following the conclusion of the Rule 9 hearing, the hearing officer recommends finding candidate filed 94 valid signatures, which is 6 below the statutory minimum of 100 under Section 7-10F of the Election Code. The hearing officer further recommends finding objector failed to meet his burden of proof to strike petition sheets as a result of circulators' alleged pattern of fraud, which must be proved in these cases through clear and convincing evidence. The hearing officer omitted a recommendation on objector's claim regarding circulators' addresses, so I recommend finding that objection is moot in light of candidates' insufficient valid signatures. So the recommendation here is to sustain the objection and not certify candidate's name to the March 2026 general primary ballot as a Democratic candidate for the office of State Central Committee Person in the 3rd District.
Thank you, Marnie. Mr. Abbasi for the objector.
Thank you, Madam Chair. I'll first say that I would ask the board to accept the recommendation of the hearing officer and the general counsel. I'll add a little bit more that in alternate grounds that objector argues that the candidate could be under is if one sheet in particular that pattern of fraud was alleged was sheet 17, where 2 lines were stricken in the record exam, one by the expert, and then the objector produced affidavits from all 7 other signers on that sheet. So even if that sheet was stricken on a pattern of fraud, that would subtract, the candidate started with 116, the expert, based on accepting the expert, took him to 106, and then subtracting those additional 7 from that one sheet if a pattern of fraud was found, because we had affidavits from all the remaining 7 good signers, would put him at 99, which is 1 under. And I'll also say that with regards to the candidates' affidavits, that they hadn't subpoenaed those the certified records from the Chicago Board of Elections for those signatures they wanted to do produce affidavits for. So even if they were accepted, there was no comparison possible to be made, so they couldn't recover those signatures. So I ask that you accept the recommendation of the hearing officer and the general counsel.
Thank you. Mr. Vaught.
Thank you, Adam Vaught, BAU GHT, on behalf of the candidate. I would ask you to reject the hearing officer's recommendation. First, related to our affidavits, as Ms. Malowitz stated, the hearing officer says they are untimely. I would point out that the objector filed a Rule 9 motion, but right before the 5 o'clock deadline for their evidence, they asked for an extension of time at 5 o'clock on Friday. I said I had no objection, and that evidence was then allowed in at Monday with the expert report from the handwriting expert and from their affidavits. At the evidentiary hearing, after I had submitted our affidavits at 5 o'clock on that Friday, there was no objection. So if we're striking out my affidavits of untimely, their evidence needs to come out as untimely. Second, it was stated that the expert was unrebutted. In fact, the expert said that he had no evidence that the people on the petition had signed it, but he also said he had no evidence that they did not sign it. So after the record exam showed 116, that is presumed to be accurate unless overcome by a rebuttable presumption, which wasn't met. So our affidavits should count if theirs do, and the expert did not present evidence that the people in fact did not sign it. So I would ask you to reject.
I have a question, Marnie.
Jennifer.
Yesterday's hearing, when we talked about Rule 9 extensions, I believe that the standard was if one party is given an extension, then the other party is given an equal amount. Is that applicable here?
That's a great question, and let me take a look at the rules so that way I'm not speaking off the top of my head and out of turn. While I'm pulling up that document, to Mr. Vaught, why 9 days late?
That's what I was gonna ask. If you knew that he was filing a Rule 9 motion.
I didn't know he was filing a Rule 9 motion. I believe, and correct me, that when he did file, he said he was having a handwriting expert, but I don't believe he said which lines were being changed.
When did you get notice that he filed that motion?
When he filed.
Then why didn't you file an extension on the heels of his motion to give you more time?
I had submitted my affidavits as rebuttal evidence, not necessarily triggering in Rule 9, but when I filed it, I asked for either to submit it as rebuttal evidence or to accept it as a late Rule 9. And so the hearing officer, at the evidentiary hearing didn't make a ruling, but he's made a ruling as part of his recommendation.
And I still am going to answer your question, Member Ballard Croft. My computer's slow for a moment unless someone has a copy of the rules of procedure handy. Oh, thank you. Thank you. Great, and bear with me because this is a very good question.
Thank you.
Extensions of time. This is 9G5. If an extension is given to the candidate or objector to rehabilitate or strike any signature, then the opposing party's period to provide other evidence to rebut that submission shall be equally extended. So I realize Mr. Vaught is saying this evidence was rebuttal evidence, but I believe it was about different voters.
Well, for the petition generally, yes, but I mean, also keep in mind, I submitted my affidavits before he submitted any of his evidence. So I was in some ways submitting things blind.
I have a question.
Oh,
When it says prescribed time or give additional time, does the hearing officer say, you've got 2 days, you've got 3 days, where is this prescribed time coming in?
So the hearing officer has discretion on that, so long as good cause has been demonstrated.
But did he give Mr. Abbasi a deadline? Because how do we figure out how much time Mr. Abbasi was given so that we can give equal amount of times to Mr. Vaught?
So it
That's my
sounds
question.
like the due date was on a Friday and you filed on a Monday, which is one business day.
Okay, that's all I want to know, how it's calculated. Okay, so
For an extension.
So, Mr. Vaught, if you knew on Friday that he was gonna be filing his Rule 9 motion on Monday, would you have filed an extension of time on Monday, asking for more time on your side?
When I filed on that Friday, I filed a submission stating that we were submitting this as rebuttal, but also asked that if the hearing officer didn't think it was sufficient as rebuttal, that we would ask for a Rule 9 and ask for the extension of time to be granted. And we cited the rule and explained, our reasoning is that, as everybody knows, this is all happening fast and quick. And we came 16 votes over 116. No idea what they were doing when they filed their Rule 9. We still didn't know what they were challenging. So we got affidavits and then submitted them before they submitted their evidence. And again, if mine is deemed untimely, I just think that if it's, I didn't object, he didn't object on the timeliness. And so if they're throwing ours out, fundamental fairness should be that they throw their affidavits out, which then puts us over, because we're talking about a candidate who is an incumbent who was found after the record exam to be 16 votes under, that now we're throwing out the candidate on the basis of, well, we'll let these in and we won't let that in. And that still doesn't get to the expert who did not state that the signatures that he was challenging were in fact not signed by the people on the petition.
Well, the point that general counsel has brought up, which I cannot reconcile, is why it took you 9 days. I can't reconcile that.
any further discussion? Do I have a motion?
I'll make a motion to accept the recommendation of the general counsel and the hearing officer on this matter.
Is there a second? Do I have a second?
Okay, well, then let's keep talking.
Or we can make a motion to reject the recommendation of the hearing officer and the general counsel and no, I gotta get it right. Marnie, help me out. And then certify the
Sure. In order for us to write an order on that, I need to have a reason that we're rejecting the hearing officer and general counsel recommendation. So can we include as a part of the motion, the reason?
Sure. So on the basis that the Rule 9 extension. Oh, give me a moment to phrase this.
Understandable, sir. I know we're putting you on the spot.
Yeah. I think that the basis would be that. My basis would be that both submissions were untimely, therefore should not be considered, therefore the candidate has exceeded the 100 signature requirement.
Okay, and as to the fact that one sought an extension and the other didn't, are we finding good cause for candidates delay?
Yes.
Okay. Any other clarifications?
I'll point out that even if they're, and I didn't object to the timeliness of their affidavits. What I objected to was the fact that they did not request any Rule 9 subpoena. All the signatures were in Chicago, so they didn't, for the signatures that they sought to rehabilitate, they didn't request from the Chicago Board of Elections the certified copies of those signatures. So even if, when they were submitted at the hearing, we had nothing to compare them to. So it was incumbent upon them, with whatever period to make a Rule 9 subpoena on the Chicago Board of Elections, so we could actually look at the signatures so the hearing officer could make a determination.
And that's what the notary stands for. The notary says this is the person before me. It's better than comparing a signature to a voter file that may be 10, 20 years old.
And what was the objection to those 12 signatures?
That there wasn't the proper signature. And so they have the affidavit and the notary says, yes, this is the person at that address, and they say they signed it. And they
So it was genuineness.
Yes.
Yes.
Okay. Give me another moment with the rules, and thank you, Mr. Bossi. Although if the board wants to vote on the motion, feel free.
Give you time.
Okay,
Yeah.
all right, thank you. I don't want to be usurping, your vote.
And I'll say on our side, we did request a Rule 9 subpoena from the Chicago Board of Elections, and the Chicago Board of Elections did produce the certified voter records with the signatures to the hearing officer, and to myself and Mr. Vaught.
All right, so as to, I can read the rule on signer's signature not genuine. This is Appendix B, IA of our rules, signer's signature not genuine. The voter's original signature on the registration record shall be examined. If in the opinion of the record's examiner, the signature on the petition is not genuine, the objection shall be sustained. Any objection based solely on the ground that the signature is printed and not in cursive form will be denied as failing to state grounds for an objection. Staff must still perform the above mentioned examination in situations where the signature is printed to determine whether there's a reasonable match. In order for a hearing officer to overturn the initial ruling on genuineness of a signature, the moving party must present the following evidence. Number one, a signed and notarized affidavit of the voter attesting that the signature at issue is or is not their signature. Number two, testimony from the voter attesting that the signature at issue is or is not their signature, or testimony of an expert. So hearing officer will rule on the genuineness of the signature and the evidence presented by the parties, and shall not overturn an initial ruling on genuineness of a signature on their own opinion. So to me, this seems to say that an affidavit is sufficient, but your interpretation of the rules is the correct one.
And if I may look at the rules.
Absolutely.
Thank you.
Did you have a comment, Member Watson?
I beg your pardon?
Did you have a comment?
No.
Okay, I just wanted to acknowledge that she is now on the Zoom.
And just for next time, Mr. Vaught, if you could file exceptions, it would help me so much to be able to evaluate all of these signatures and know the answer to all of these questions in advance. I said that like 3 times yesterday too, so just so you know, it helps so much.
My checklist for next time.
Thank you.
I think we have a motion pending. It has not been seconded.
Right. I'm waiting for a potential.
Oh, okay. Apologies.
No, and I appreciate everyone giving extra time on this, since this is
We want to get it right.
we want to get it right, and these are some fact specific and evidence specific determinations that need to be made.
Yeah, I'm just trying to go through about Rule 9 subpoenas. Where it says, yeah, I mean, I'll say for evidence, it says, any voter registration records must be certified by the issuing election authority. And I'll go to the Fritchie versus Romanelli case, where the hearing officer had nothing to compare these signatures to. So that was my objection, that there was no Rule 9 subpoena was issued, and whereas we did request a Rule 9 subpoena, we had everything in front of the hearing officer. In this case, there were no certified board records. He had nothing to compare the to the actual, to overturn, the record, the record exam rulings are prima facie correct. In order to go over them, they would need to, actually make a comparison. And the way to make a comparison is to get the certified voting records.
Thank you, Mr. Bonnet. We do have.
Marnie, I want
Yes.
to point out, one of the sentences or points that the hearing officer makes.
Okay, can you give me a page number?
Well, just in summary.
Oh, in the summary. Okay.
Even if deemed timely, the hearing officer recommends, and this is about your Rule 9 motion, Mr. Boyd. Recommends finding candidate failed to meet his burden of proof as the affidavits were not accompanied by voter registration records containing voter signatures.
Okay,
So even if the Rule 9 motion had been timely, the hearing officer finds that you did not produce affidavits to support the voter signatures.
Well,
And which the rule that was just read requires as one of the requirements is they could submit affidavits. Am I correct in recalling that Rule 9?
So I'm making
For
sure
January.
you submitted affidavits, but not voter records.
Correct.
Okay, so the issue is the reverse.
Okay, I just want to clarify that because it seems that he's hanging his hat on.
The timeliness. And even if we're going to say it was timely, we're still lacking
He's
the
still
voter
rejected.
record.
Right.
Okay,
Yeah, the hearing officer said that even if he did consider them, he wouldn't rehabilitate those signatures. So
well, I guess I would just say, to the rule you first stated, but then also, that's what the notary stand for, is to say the person before me is the one signing this. That wipes away probably 500 histories of common law tradition by saying that the affidavit, the notary signature doesn't, establish that the person standing there is giving the testimony. But you guys got a lot going on. So
But
we can
doesn't
go
meet
back.
the criteria of the rule.
Well, that's what I was gonna ask Marty. I just want a clarification. So does it meet the criteria of the rule? Because when you read it, I thought that it did not.
let me look again at the beginning of the rule, because it was the first two sentences. I know the last couple of sentences said we needed an affidavit or testimony. But let's look at the first couple of sentences again. I'm pulling up the rules now that my computer's decided to start working.
All right, just kind of want
I know.
Totally, we should get this right, and I appreciate everybody's patience on this. We'll double check that the hearing officer is correct.
and I'd say generally electoral boards don't just accept affidavits for signature not genuine for what they're worth. Just that by itself, having an affidavit reestablishes the signature. I think it's a comparison is made, and the hearing officer was within his rights to say, if I'm going to accept these, I need to make a comparison.
And I do think that that's what the first part of the rule said, which is why I'm pulling it up to find it for you right now. Okay, so we're back to Appendix B, IA. Signer signature not genuine. The voter's original signature on the registration record shall be examined. If in the opinion of the record's examiner, the signature on the petition is not genuine, the objection shall be sustained. So I shall be examined does say to me that they should have looked at the original signature.
But that's by the record examination.
Oh, that's at the records again. You're 100% right. Okay. Well, does Jordan, Andrew, our Deputy General Counsel and resident expert on rehabilitating signatures have anything to add?
She's coming.
Thank you.
And again, I'd say based on, if the hearing officer made a determination that without this, I can't recover it. I think that's the evidentiary ruling on these affidavits, that there isn't, that in his mind, the burden of proof is not met to rehabilitate these signatures.
Well, and just one final thing, playing tennis here, is that their affidavits at the evidentiary hearing, I challenged on the basis that the affidavit saying I didn't sign it, signed by people with handwriting, sure looked a lot like the handwriting signatures of the people signed on the petition. So he didn't examine the affidavits compared to the petitions for his affidavits, but he said he can't examine my affidavits because he doesn't have the voter signature. So again, it's what's good for one should be good for the other. We're not playing equally.
Is Jordan there to speak?
I am here. At the end of the day, I recognize both parties' arguments, and I would support the recommendation of the hearing officer, as he was the person in the room at the Rule 9 hearing conducting the evidence, able to evaluate the veracity of all of the evidence presented, and has made his recommendation as such.
All right, where are we? Are you going to reiterate your motion, or do we have another motion put forth?
From my perspective, my motion's still pending, but recognize it has not been seconded. So no, I'm not intending to modify my motion.
Do we want to, sir, are you able to read back the motion by chance? No, it was a really long time ago.
It might take a little while to find it eventually.
I think it was,
Or would you like to rephrase just the way it's fresh in our minds?
I think it was a motion to reject the recommendation of the hearing officer and the general counsel. On the basis that the Rule 9 extensions, now I'm gonna get all confused, give me a moment, that the Rule 9 extensions were timely made.
Made in good faith.
Made in good faith, thank you.
Do we have a second? All right, Marnie,
Okay, would you like me to suggest a motion that would adopt the recommendation of, which would just be to, you know what, let me say it for you fully, so everyone knows what they're voting on. Based on my notes. So is there a motion to accept the recommendations of the hearing officer and general counsel, sustain the objection based on insufficient signatures, and not certify the candidate to the ballot?
So moved.
second. Roll call, Amy.
Ms. Bellercroft,
No.
Ms. Craig,
Yes.
Ms. Genovese,
Yes.
Ms. McCrory,
Yes.
Mr. Brett,
Yes.
Ms. Watson,
No.
Vice Chair Turvin,
Yes.
Chair Donahue.
Yes,
Motion passes.
thank you both.
Thank you.
And thank you to Jordan for letting me call on her, but she's truly our best rehabilitating signature. And has been a great help to me on those issues. And thanks to council.
All right.
The next case.
Marty, yes,
All right.
next case.
Next case is Newsom versus Severino and Isquith, 25 SOEB GP 531. Council can stand near the white paper. That would be very helpful. And certainly keep your voices up once you start speaking. So I will read my recommendation. Objector Newsom, who's represented by attorneys Jeffrey Meyer and Christine Svensson, objected to the nomination papers of Joseph Severino and Ranch Isquith, Republican candidates for the offices of governor and lieutenant governor, both represented by attorneys Perry Abbasi and Chris Abbasi. Objector's petition makes individual signature line objections and alleges that circulators engaged in a pattern of fraud. Candidates filed a motion to strike and dismiss arguing this was a bad faith shotgun objection, that certain circulator objections were not properly pled when they were handwritten within the recapitulation sheets. So we refer to that as the whole sheet objections, and that the pattern of fraud claim was insufficiently pled. The objector explains in response that the objection was filed in good faith, and that the objector objected to far fewer lines than in a shotgun objection. So following a records exam of 2,522 lines, a total of 1,588 line objections were sustained. So about 63% of challenge lines were sustained, resulting in 4,748 valid signatures, which is 252 below the statutory minimum of 5,000 signatures required by section 7-10A of the election code. Candidates filed a Rule 9 motion seeking to rehabilitate 70 signatures, but candidates did not file any evidence with their Rule 9 motion and did not seek any Rule 9 subpoenas until the last day of the 3-day Rule 9 motion period. Candidates requested an extension of time to submit Rule 9 evidence, which the hearing officer denied for lack of good cause. But even if all 70 signatures subject to the Rule 9 motion had been rehabilitated, candidate would still have been 181 signatures below the statutory minimum. Nevertheless, the hearing officer conducted this matter. The hearing officer recommends finding that in the event the board decides to consider the tardy Rule 9 evidence from the candidates, 2 signatures were rehabilitated and 68 were not. The hearing also served as an evidentiary hearing on candidates' claim this was a bad faith shotgun objection, arguing that objectors wrongfully objected to signature lines based on genuineness of the signature without a proper view of the voter records before filing the objection. As to candidates' motion to strike, the hearing officer recommends, and I agree, granting the motion in part and denying the motion in part, finding objector's allegation related to a pattern of false swearing and containing a whole page objection are insufficiently pled under the board's rules of procedure and fail to fully state the nature of the objection respectively, and granting candidates' request to strike these objections under section 10-8. The hearing officer recommends finding objector's allegation of bad faith is an issue of fact requiring an evidentiary hearing and thus is inappropriate for motion to strike. So the remainder of the motion should be denied. On the issue of bad faith, on the merits, I agree with the hearing officer that candidates have offered no evidence demonstrating that this is a shotgun or bad faith objection. And in fact, 63% of objectors' objections were sustained. I also recommend adopting the hearing officer recommendation that the Rule 9 evidence was untimely and that candidates submitted 4,748 valid signatures, which is 252 fewer than the minimum of 5,000 signatures required for ballot access under section 7-10A. Therefore, I agree the objection should be sustained and that candidates' names should not be certified to the ballot as Republican candidates for the offices of governor and lieutenant governor. Candidates then filed exceptions to the hearing officer's recommendation, many reiterating previous arguments and disagreeing with the substance of individual Rule 9 rulings. But again, even if candidates' Rule 9 motion had been timely and had been granted in full, candidates would still have insufficient signatures for ballot access. The new matter that was raised in the exception is that candidate Isquith was not properly served in this proceeding. So after reviewing board records, it is true candidate Isquith was not served by certified mail and did not execute a waiver form in this case. However, counsel appeared on behalf of both candidates on November 11th, 2025, a full week before the electoral board convened for the first time, and candidate Isquith participated throughout proceedings, effectively waiving any objection to service, and never raised the issue of improper service, as far as I can tell, until after the hearing officer's recommendation was issued. But even if lack of service on candidate Isquith is not waived by his appearance and participation, and even if the service issue was raised timely, it's undisputed that candidate Severino executed a waiver of service form and therefore was properly served. Candidate Severino submitted insufficient signatures and Illinois law precludes candidate Isquith from appearing on the ballot as a candidate for lieutenant governor without an accompanying gubernatorial candidate. My citations to that are to Illinois Constitution, Article 5, Section 4, which requires a joint election for governor and lieutenant governor. The other site is to Section 7-19 of the Election Code, which prescribes the form of the ballot for the primary. And it provides that the names of each team of candidates for governor and lieutenant governor are printed within a bracket. So that is the recommendation. I realize it's a complicated one, but at the end, these candidates are 252 signatures under. And even if the Rule 9 motion is deemed timely, it's only rehabilitating 70 signatures. So the candidates would still be under.
All right. Thank you, Marnie. Mr. Meyer,
I'm gonna defer to.
you're
Ms.
going to
Benson.
defer to Ms.
I'm
Stevenson.
well
That'd be
supervised.
fine.
Good morning to
Is
the
that-
board and the general counsel, Christine Svensson on behalf of objector Terrence Newsom. So we of course agree with the hearing officer. Hearing officer Herman went through a painstaking process, as you can tell by his 19-page written decision. And he left no stone unturned. He considered every single argument of the candidates. And so he got everything right. And other than the fact that we disagree, we're not waiving our arguments with respect to the pattern of fraud, but other than that, he got it right. At the end of the day, candidate's short. He did not submit timely evidence. He doesn't have enough signatures. The rule, we went through the numbers don't lie. The records examination was on November 25th. The Rule 9 period he got until December 2nd because of the Thanksgiving holiday. And even with those extra days, no affidavits were submitted, no certified voting records. They have no good cause to try to extend that Rule 9 motion period. Then it's interesting, and of course, only 70 signatures were even mentioned, but it was just argument. There was no evidence submitted. I will just acknowledge the fact that they submitted this quote unquote evidence exchange on December 13th, because I know council is going to bring this up. This evidence exchange still didn't provide us with any certified records and no admissible evidence. And by the way, December 13th is 18 days after the records exam and 11 days after the Rule 9 period ended. Way, way late. No good cause shown. All they have left is bad faith. That's all they have. This case is distinguishable from the case they're going to talk about. They're going to talk about Daniel versus Daly. That case involved an objector who challenged 91% of the signatures. We challenged 39% of the signatures. And by the way, we got a 63% sustained rate. Also, Daly is distinguishable because that objector wouldn't testify, and so a negative inference was drawn against his what his testimony would be. In this case, our objector showed up and he explained the process. He explained that there were 3 different teams that went through these signatures. He didn't have to do that, but he did it. He testified very credibly, and his testimony was unimpeachable. And by the way, the Nader case says that the Electoral Board has no jurisdiction over the processes involved with determining or how the objector goes about coming up with his objections. So the hearing officer threw him a bone at that one and let them cross-examine our objector. Finally, they're going to bring up due process. This is the opposite. This is where every single opportunity to try to rehabilitate signatures was granted. They missed every deadline. They didn't submit evidence. I'll just finish with their statement brief actually is the candidate's testimony. It's a cut and paste job where the candidate says, they're pushing me below. You can see the candidate's own words. It should all be disregarded and thrown out. At the end of the day, they're short.
Thank you, Ms. Svensson. Mr. Abbas.
Thank you, Madam Chair. So after the record exam, the summary of the record exam showed the candidate was minus 252. What the candidate's arguments are is that we get to back above 5,000 with 3 parts. The first one, we objected, we filed a motion to strike on bad faith. In that, if you looked at the recap sheets, virtually every time address, voter not registered was checked, signature not genuine was checked. The Mr. Newsom, the objector, testified. He said, when he put this together, he was in his basement, he had a Republican voter file, so he could see the registrations. He wasn't seeing the signatures, and this was a verified petition, a verified objection petition by him, that he was saying all about 2,300 signatures were not genuine without him even looking at one of them. And that's what Daniel versus Daly has cited is that there's you need to have a basis to say that this signature is not genuine. You have to look at the actual record somewhere, whatever board of election that you can look at them at. But it appears whenever whoever filled out the recap sheets, whenever the not registered was checked, not genuine was checked, and to allow that would set a terrible precedent by this board in that it's letting objectors just object to, in this case, 2,300 signatures. It's not genuine without having looked at any of them. Would be just basically mirroring when you say not registered, it's also not genuine. So that was, and additionally, their circulator objections, their bad faith objections, stated that the reason was the high number of not genuine signatures, despite not the objector not looking at these signatures to actually make a determination they're not genuine. So that's why we've argued it's a bad faith objection. But further, even if you didn't throw out the whole thing on bad faith, we'd argue that all the signature not genuine sustained should be thrown out on bad faith for the reasons stated. And in fact, the results of the record exam show only 76 out of the 2,300 and some change allegations of not genuine were actually sustained. That's only 3%, which is further evidence that bad faith or that his non-genuine allegations were made in bad faith, that only 3% of them were actually sustained. So that there were 76 there. In addition, we raised that a number, I believe about 50 address incomplete objections that were sustained by the board, where, at the hearing, we went through some of them. They didn't write the municipality, or it might have been illegible, but that's not under the rules. Illegibility does not equal incomplete. And I cited a case, Mahoney versus.
Mr. Abbasi, you need to wrap it up, please.
Wrap it up. Okay, and then to the Rule 9, the not registered. The candidate submitted registration from the State Board of Elections. He did not get the certified for 148. That's 10% of the not registered. That's a huge margin that you're really. That's not a sufficient record exam. So given that amount, given it's a statewide race, more time should be accepted, and the registrations, the evidence submitted should be accepted because it's from the board, and the Constitution says the board oversees registration.
Thank you. Marty, any response?
There was a lot in there. I would say the one thing is that our rules do specify that you have to get a certified record from the election authority in order to rehabilitate signatures in that method. So I don't think that particular argument is valid, but at the end of the day, I don't think it matters because it's only a challenge to 70 signatures and we're 252 under.
Do I have a motion or discussion? A motion?
I'll make a motion to accept the recommendation of the hearing officer and the general counsel.
Is there a second? It's been moved and seconded. Roll call, Amy.
Ms. Beller-Croft,
Yes.
Ms. Cray,
Yes.
Mr. Nevesi,
Yes.
Ms. McCrory,
Yes.
Mr. Verrett,
Yes.
Ms. Watson,
Present.
Vice Chair Turbin,
Yes.
Chair Donahue.
Yes.
Motion passes.
Thank you.
And thank you, counsel. I know the clients were not always easy in this case, but you are the three of you were great. So thank you.
And thank you for accommodating me. I'm going to be heading over to the Daily Center now. Okay, so thank you.
All right. Marnie, do we start then back at
1A.
square one?
Square 1A, Statham versus Bryant, 25 SOEB GP 100. So Objector Statham, represented by attorneys Craftucker and Smith, filed an objection to the nomination papers of candidate Bryant, who's represented by attorney Jeff Meyer. Candidate is a Republican Party candidate for judge of the circuit court for the 9th Judicial Circuit, Kavanaugh vacancy, Kavanaugh with a C. Objector made petition signature line objections, alleged circulator affidavits were incomplete, and said the statement of candidacy insufficiently identifies the office sought because it omits candidate Kavanaugh vacancy. Objector later withdrew the objections to the statement of candidacy and alleged notarial deficiency, so I will not summarize the briefing on the motion to strike and dismiss in part, as the motion is rendered moot because it only addressed those 2 objections that were withdrawn, leaving only the signature count issue left in this case. A records examination was held. The statutory minimum signatures under section 7-10H of the election code was 500, and candidate filed 522 signatures. Following the records exam, the candidate had 484 valid signatures, which is 16 below the statutory minimum. Candidate filed a Rule 9 motion, and the parties were able to reach stipulations on certain signatures. And a Rule 9 hearing was held on the remainder, at which the hearing officer upheld all staff rulings. Following the Rule 9 hearing, the hearing officer recommends, and I agree, finding that candidate had 483 valid signatures, 17 below the statutory minimum of 500 for this judicial office. I further recommend denying the motion to strike and dismiss as moot, again, because the relevant objections were withdrawn. The candidate here filed exceptions to the hearing officer's recommendation, challenging certain Rule 9 hearing rulings. So in the first group of signatures at issue, the voter omitted either a street name or both the city and county from their signature on the petition. My recommendation is that in these circumstances, an affidavit is insufficient to rehabilitate an incomplete signature if the signature did not meet the basic requirements of section 7-10, which requires the street address or rural route number of the signer, as the case may be, as well as the signer's county and city, village, or town and state, which is cited on page 3 of your packets. Candidate cites an unpublished case, Mahoney versus Municipal Officers Electoral Board. Mahoney is Mahoney. It is cited on page 3 of your packet and argues that substantial compliance was found in a case in which the voter omitted the county only from the petition signature. But even if substantial compliance is applicable in this context, the information was insufficient for the records examiner to find the voter, as it was missing either a street name or both city and county. And I think these lines cannot be said to even substantially comply with the election code. So I agree with the hearing officer recommendation as to these signatures. Second, for the challenge signatures in which the voter presented affidavits based on the voter's recollection of where they were registered to vote at the time they signed the petition, under Appendix B, Section IB, for an objection that the signer is not registered at the address shown, an affidavit from the voter attesting to the registration address will be deemed insufficient to rebut voter registration information. So to permit rehabilitation by affidavit would contradict the rules of procedure and treat the recollection of a voter as more reliable than the actual public voter records themselves. So again, the recommendation is to deny the motion to strike and dismiss as moot, to sustain the objection, and to not certify the candidate due to insufficient signatures.
Thank you, Marnie. Objector, Mr. Smith.
Good morning, Attorney Tyler Smith, SMITH, on behalf of the objector, Lawan Statham. Good morning to the board and the general counsel. As the general counsel and the hearing officer's report stated, the objector's verified petition raised objections primarily to signatures on the candidate's petition sheets. And after the result of the Rule 9 hearing and the hearing officer's ruling on the challenges to the Rule 9 motions, the candidate is below the statutory required minimum signature count of 500 signatures for this office. Regarding the candidate's objection to the hearing officer's recommendation report, the first three signatures challenged there for the incomplete address only had the initial numbers. There was no street address provided, there was no municipality provided, and there was no county provided, which, as the general counsel's recommendation indicates, is distinguishable from the unpublished appellate decision cited in that objection. So there's the objector would agree and state that there is not substantial compliance with requirements of section 710 of the election code, which clearly states that the petition signer must provide the street address or rural route number, municipality, the county, and the state. Additionally, for the second set of arguments in the candidate's motion there, the board's adopted rules for the established 2026 candidate cycle clearly state that an affidavit is not sufficient or admissible evidence to rehabilitate a stricken signature for the signer not being registered at the address. Section 3-1.2 of the election code states that a qualified primary elector must be registered to vote at the address shown opposite his or her listed signature on the petition sheet at the time of signing the petition sheet. And under Article 7 of the election code, petition signer must be a qualified primary elector of, in this case, the Republican Party. Because the signature exam results showed that these voters were not registered at the address listed at the time of signing the petition, these signatures are not qualified primary electors in the meaning of the election code, and the candidate is below the minimum signature count. Thank you.
Thank you, Mr. Smith. Mr. Meyer?
Thank you, Jeffrey A. Meyer, M-E-Y-E-R, on behalf of the candidate who appears with me this morning. A couple of points, and I think this does come down to the Rule 9 rehabilitation evidence. In terms of the address incomplete, I think that with respect, general counsel and the hearing officer and opposing counsel are reading the Mahoney case entirely too narrow. While the facts may be distinguishable in the Mahoney case, for example, it was a missing county or a missing city, not with the facts here where we're maybe missing a street name. If you read the Mahoney decision itself, it gives the underlying reasoning behind the rule that they announce in that decision. And that is that just like with circulator addresses, they cite the Cunningham case for this, Cunningham, C-U-N-N-I-N-G-H-A-M. If after submission of a voter affidavit, you're able to ascertain and identify the location of the voter, and then you would be able to effectuate process if necessary on that voter, then that evidence is competent to rehabilitate the missing address or the incomplete address. That's what the Mahoney case says. And that's what we had here. We had affidavits from the voters that attested to the rest of their address. So much so that it would have been easy then to identify or locate them if necessary to effectuate process. If that's the public policy reasoning in the Mahoney decision, then the evidence that we submitted here is sufficient to rehabilitate the incomplete address, just as it was in that case, even though the facts are a little different. In terms of Mahoney being a Rule 23 opinion, I'll note it's from 2021. That's after the amendment to Rule 23. So these are not summarily, not precedential anymore. These are precedential decisions, just not published. In terms of the affidavits as to the signer not registered at the address shown, these weren't simply affidavits referring to what the voter's recollection was. They were affidavits that said, I barely believed I was registered at that address, and here's why. And in almost all circumstances, it was, I had moved within the district. When I moved, I changed my address at the Secretary of State's office. I requested at the Secretary of State's office that my voter registration also be updated. And then for reasons unbeknownst to the voters, even though many of them also averred they had actually voted in elections after moving, the registration information shown on the voter records that we've also provided and that the state board has wasn't updated. Voters can only do what they can do. They can only request that the registration address be updated. Election authorities are not doing that. That's not something that's within the control of the voters. And that's what we had in almost all the rest of these circumstances. The affidavits didn't just simply say, I believed I was registered to vote here. It averred, I asked to change my address. I asked my registration be updated, did what I thought was necessary to do that. And in one case, we actually submitted along with the affidavit the written request that the voter had. He had a copy of it from when he went to the Secretary of State's office asking to update his registration as well. All of that evidence was summarily disregarded because of the hearing officer's very strict interpretation of Appendix B to those board's rules of procedure. We believe they should be considered, and we believe that the candidate's signature should be rehabilitated and should above the statute. Thank you.
Thank you.
Madam Chair,
Yes, member.
I have a
Watson.
question. You say that the information was not accepted by the hearing officer. And what is the reason that the information wasn't accepted by the hearing officer? Again, please. I could not hear you clearly.
Member Watson, my understanding based on a reading of the hearing officer's recommendation and based upon his comments during the Rule 9 hearing is that he didn't believe these affidavits were competent evidence under Appendix B to the board's rules.
And why is it that he didn't believe that they weren't competent?
My understanding is that he didn't believe they were competent because, and I'll read from, this is Appendix B, 1, subsection B. And an excerpt here, an affidavit from the voter attesting to their registration address will be deemed insufficient to rebut voter registration information supplied by the board or local election authority. I believe that's what he's relying upon.
Can I just clarify these?
And wait, if you could.
Continue, member Watson.
I'm just trying to understand that the hearing officer would not accept this information, notwithstanding the type of information that it was. You say that the information showed in some cases that the signer had moved, that they had gone to the registrar to make sure that their information was recorded correctly, that you had copies of letters that showed that they had requested that their voter registration be changed in some cases. Is that correct?
That's substantially correct. That not necessarily that they had gone to the registrar themselves, but that instead the voter had gone to the Secretary of State and updated their address with the Secretary of State, and at that time requested that their voter registration information be updated as well. And in some cases, in fact, most cases, we had then a copy of the updated driver's license, and in one circumstance had an actual copy of the separate request, because there's a difference if it's a real ID or if it's a non-real ID. If it's a non-real ID, you still have, I think under the administrative rules, are supposed to sign something saying also update my voter registration. If it's a real ID, it's supposed to be automatic. In the case where, one case where we had a voter who did not have a real ID after the address change, he had a copy of the written request for the Secretary of State to also modify or update his voter registration.
I have a question.
Wait just a sec. Member Watson, are you finished?
And Marnie, you're
Yes.
saying that your hearing officer is saying that notwithstanding all the effort that the signer has made, what is the hearing officer saying?
So the hearing officer is following the rule in our appendix, which says that an affidavit is insufficient to over a voter record. A voter record of an election authority is a public record, and he is following our rule, which says that the voter record is supreme.
So the voter record would not have given the information that was necessary.
Under
Am
the
I
rule,
incorrect? Would the voter record have given the information that you received in the affidavit?
no, there is additional information in the affidavit. However, the hearing officer was following the rule, and
So the hearing officer is saying that because they did not have the voter record, that they couldn't accept any of this information. Is that right?
essentially, but the problem is, and I'm assuming that the voter record contradicted the affidavit as to the location of registration, although let's have Mr. Meyer confirm that for me.
That's
So-
correct.
So the
voter records that
affidavit,
had not been corrected, voter records that had not been updated as requested by signers,
That's substantially correct, Member Watson.
Throw this candidate off the ballot because state employees didn't get to do their job. Am I correct there somewhere?
That's our belief in the majority of these circumstances.
That is the objector was interested, that is the candidate's alleged argument to the hearing officer did not know and applied the rules as written by the and adopted by the.
So can we talk about the numbers quickly? So we're 17 below right now.
Correct. There are 18 affidavits at issue.
Okay, so 18 affidavits at issue. So the first three are not there. So are you saying that for all 18 of those affidavits, there was evidence attached showing that they had actually filed?
It varied from signature to signature, but as to the first three were just missing address only. Then there were 13 that were missing address or incomplete address and not registered address shown, or pardon me, just not registered at address shown. Then there were 2 that were not registered at address shown and also supposedly missing some address information. So as to the last basket of 13 plus 2, 15, where not registered at address shown was an issue, for each one of those, there was an affidavit referring to their belief, the efforts they took to update their address, their registration, and then in many cases also then copies of driver's licenses, or in that one case, like I said, the actual form that they submitted also to the state's office.
But even taking that as true, you're still 2 signatures on it.
No.
Question, please.
Yeah, just a second.
I can't get past the fatality that there were no addresses on these lines. And based on our rules, an affidavit cannot rehabilitate a line that has no address on it. How many of those 15 actually had an address on the line? Because as you can understand, we must know where this person lives in order to determine whether or not the petition is valid, because they live within the jurisdiction to vote for this one.
Member McFoy, I understand your question. As it was 3 that were only address incomplete. There were, like I said, 2 where there was address incomplete and also an allegation not registered address shown. So I think we're talking about 5 here with your question. I understand the board's rule. I believe the board's rule is in conflict with the holding in Mahoney. I think the holding in Mahoney is controlling, and it says that if an affidavit is provided by a voter, that would then provide the rest of the missing information so that the board, if necessary, could effectuate process to compel the appearance of that voter to answer whatever questions there may be. That requires, or that instructs then that this signature should be rehabilitated. So I believe the board's rule, you're correct in interpreting the board's rule, but I believe the board's rule is in conflict with the court's holding in Mahoney, and I think the Mahoney decision is controlled.
I don't necessarily agree with you. I think missing a county on a address line is negligible at most. Anybody can look up an address and find, but when they're missing an address, you cannot verify that that person actually lives within the jurisdiction that they're required to live in order to vote for this particular candidate.
And I
That's
think,
where I have a problem with it.
and I think that it's not, I guess it depends on missing an address. So we had, for example, one where there was or 2 where there was a street number, and I think it had the city as well, but didn't have the street name. So if you were to search 1050 Macomb, Illinois, obviously there could be more than one 1050, but then the same could be true if you had 123 Main Street and we're missing the city. So if 123 Main Street missing the city, but you have an affidavit that tells what city 123 Main Street's in, if that's sufficient, then having 123 but not Main, but having the city in an affidavit that completes it, I think that those are the same. I think it's apples and apples and not apples and oranges, but I understand your question.
Marnie, any further comments?
I agree with the recommendation of the hearing officer here, and I would just note that I understand the Mahoney argument. But I would say that Mahoney is persuasive. It's a Rule 23. It's not binding. And so I don't feel comfortable saying that our rule is invalid. So that's pretty much where I am there. For me, the motion I would recommend would be to accept the recommendation of the hearing officer and general counsel to deny the motion to strike and dismiss as moot, to sustain the objection, and to not certify the candidate to the ballot as a Republican Party candidate for judge of the circuit court for the 9th Judicial Circuit. And I think the unfortunate, due to insufficient signature things, and the unfortunate thing here is that the signature limit or minimum was 500 and the candidate only submitted 522 signatures. So I think this is sort of a first time candidate mistake to not know that you can't just get 522 signatures. And
I may just briefly speak to that. This was a vacancy that was posted. So it was a vacancy from a sitting circuit judge. He tendered his notice of retirement on the last day before for this office to be on the initial filing period. It was then certified by the state board the following Monday. So there was literally just a couple of week time period in which to collect signatures. It's not a first time candidate issue. There was a very, very short calendar time frame in which to collect valid signatures. She's the only candidate to file.
Now I understand, and that there were 2 others who called me very, very upset that they didn't know about the vacancy, and so I get it.
Yeah, I mean, Mr. Meyer, I believe that you've made every argument you can.
Thank you. I appreciate that.
But do we have a motion?
I'll make a motion to accept the recommendation of the hearing officer and general counsel on this matter.
Is there a second?
Second.
Roll call, Amy.
Ms. Ballard Croft,
Yes.
Ms. Craig,
Yes.
Ms. Genovese,
Yes.
Ms. McCrory,
Yes.
Mr. Brett,
Yes.
Ms. Watson,
Present.
Vice Chair Turbin,
Yes.
Chair Donahue.
Yes.
Motion passes.
Thank you for your time.
Thank you.
And if I
Madam Chair,
Yes, ma'am.
I have a question to the general counsel. These rules that you keep referencing, who wrote them?
They're the rules of procedure that the board has used for years.
Has used for years?
Yeah, they were already written when I started working here almost 6 years ago. There have been a couple of amendments over the years, and every time we explain to the board the amendments that have been made, but they've all been very minimal. So I can't tell you exactly who wrote them for the first time. But I can tell you that most of the changes that have happened to them since I have been here have been dividing the rules into subsection numbers. However, Bernadette is willing to weigh in on this question if you would like.
Yeah.
Thank you.
I began in the legal division here in 2009. So the rules are similar even back to 2009. And I think the discussion today revolved a lot around a rule that actually ties into in the election code, section 7-10, about making nominations and signers. And so if you're going to sign a petition for a candidate for the primary, you have to enter your address that you are registered at.
Oh, no. I'm not questioning that, Bernadette.
No, I'm just saying not the one you think you're registered at, which we know all the time that happens. You think you updated it or it wasn't processed. It's important to have a voter maybe check. We do have mobile devices, check, see if you're registered there before you sign it, or on the back end, unfortunately, you do have to do a review of signatures to make sure that the person entered the correct one, or, so you could cure it before you file the petition.
No, Bernadette, I don't want, and Madam General Counsel, I don't want to give the impression that, I was questioning in this particular case, because most cases have their specific particularities, and either counsel can argue either way. I was just wanting to be refreshed on when and where the rules had been originally done. Thank you, ladies.
I don't think this rule has changed in a fairly long time. I don't think it's one of the ones that has been modified since Marnie came on, or even since I had been on, because the statute itself hasn't.
Thanks.
Thank you, Member Watson. Any
Yeah, I
further,
I-
Member Craig?
Comment. I want to thank Mr. Meyer for bringing to our attention that the voter registrations are not getting processed in a timely manner. I know we have liaisons with the Secretary of State, and I know that we can send something out prior to the next election that says, let's update these as quickly as we can. Let's turn these over as quickly as we can. Because
I
we
agree
don't
with
just
that.
get them from the Secretary of State. We get them from a lot of other agencies too. So thank you for bringing that to our attention, because that is something we
Right.
definitely work on.
Right.
Thank you, Member Craig. Next, Marnie.
Next is agenda item 1B, Holbrook versus Howgie, 25 SOEB GP 105. This case is about notarizations. The objector, who is represented by attorney Brian Drew, filed an objection to the nomination papers of candidate who seeks the Republican nomination to the office of representative in the General Assembly for the 107th Representative District. The objector contends that candidate's statement of candidacy is deficient because the county on the notary jurat is left blank. Additionally, for petition sheets 1 through 92, the objector alleges the notarizations are insufficient because the jurat is incomplete or contains errors in completion. The candidate filed a motion to strike, arguing that technical notarization defects are generally not fatal to the validity of nomination papers. And so just to clarify, are you here on behalf of the objector or the candidate?
The objector. I'm Brian.
Excellent, thank you. Here, the hearing officer recommends finding the candidate has actually complied with the election code because the notary jurat on the statement of candidacy identifies the state of Illinois as the jurisdiction. The hearing officer further notes the candidate filed an affidavit indicating the statement of candidacy was notarized in Macon County, and the objector conceded that no actual fraud exists in this case. As to the petition sheets, the nomination papers can be read as a whole to clarify that they were notarized in Illinois. Alternatively, as these are mere technical mistakes, candidates' notarizations substantially comply with the election code. I agree with the hearing officer and recommend specifying that compliance is with section 8-8, which governs nomination papers for candidates in the General Assembly. Therefore, the recommendation is that the objection be overruled and that the candidate be certified to the ballot as a Republican Party candidate for the office of representative in the General Assembly for the 107th Representative District. And as the hearing officer suggests a ruling on the merits, the motion to strike can be denied as moot.
Mr. Drew.
Thank you. I'm Brian Drew, BRYANDREW, on behalf of the objector, Holbrook. In this case, the statement of candidacy and as well as all the petition sheets, there are issues with the notary jurat that is set forth in all of them. It is an accurate assertion in the statement of candidacy. There was the state of Illinois listed, no county. In petition sheets 1 through 3, state of Illinois was listed in the notary jurat, but not a county. But particularly October 8th, October 10th, and October 27th, those are different days. And that's where petition sheets 4 through 92 are all set out. Those all have no state nor county in the notary jurat. And when we look at the election code sets forth what has to be done. And the word shall is used there. In the election code, it says it shall be in the form as set forth herein. And in that form, it says that the notary jurat has to have the state as well as the county. When you go to the Notary Public Act, excuse me, it also says that it must be evidence the jurisdiction in which the notary took place in order to verify that notarial jurat in that instance. And it sets forth that you can do it in one of two ways, either the form set forth in the Notary Public Act, which also has state requirement as well as county requirement, or as set forth by law in another place. If you go into the election code law, the form set out there requires both the state and the county. I will concede that not having the county as it relates to this particular instance as to where it was notarized is probably not as substantial as not having the state. I think that is something that one could look at, and maybe, although I would disagree because it is a mandatory requirement and the word shall is there, therefore mandatory requirements cannot be overlooked even if there is no fraud. And we did acknowledge that there was no actual fraud in this case that was evidenced by the circumstances and the note or the affidavit provided by the candidate. But in that affidavit merely says it was signed in Macon. It wasn't from the actual notary themselves, it was merely the candidate. So when you look at this, not having the state, that is a prerequisite for having the jurisdiction of where the notary was done. Notaries are only have the jurisdiction to notarize signatures in specific geographical locations. In this instance, the state of Illinois. And without setting forth in that notary jura, the state in which the signature was had and notarized, then there is absolutely no way of knowing that the notary was properly done in the state of Illinois. And so as we move forward and look at this, even though there was no actual fraud here, when you move forward and look at future cases, when you have future candidates and they have notaries coming in to do it, how will anyone know where the signature actually took place? How will we snuff out fraud in that circumstance? Because what will take place at that point is someone could have a notary from Illinois and sign them off in Iowa, or they've moved to Missouri, they've moved to some other state and they're no longer living in the state and they notarize your signature in a different state. That's not a valid notary.
Okay.
How will we know without that state being set?
All right, just a second. That's enough. You've had your 3 minutes, all right? You stated your point. Are you Mr.?
No, I'm just
Okay.
stretching.
You're just.
I was engaged.
All right, I thought you wanted to make a comment. No, sir.
That's it.
Is there someone in Springfield? Yes.
Yes.
Are
My name
you,
is John Hauge, I'm the candidate.
okay,
My name is John Hauge, I'm the candidate.
please proceed, spell your name and you can go from there, sir.
Hauge, Hauge. Obviously, I agree with the hearing officer's recommendation when he reviewed the facts. I wasn't familiar with how the jury worked. I went off of this candidate's guide, which called for all my documents for my nomination papers to be notarized. I went to an official registered Illinois notary public, had them proceed to do their stuff, and it wasn't until Mr. Holbrook's objection that I found out about this requirement with the state and the county thing. In reviewing some of the case law, I think the hearing officer did as well. There's been a large volume of case law where incomplete or errors in the jury have been overruled and said that they didn't need to be, they would overrule a shall based on this substantial compliance. I argued that I had substantial compliance in the fact that I went and got a valid Illinois notary public to notarize these documents. Mr. Drew, I look at it as a straw man argument about talking about using a Missouri notary public. He cited case law for that, but my notary public was registered in Illinois. I did file an affidavit just to verify my assertion in my rebuttal brief that this was done in Macon. We did not secretly haul our nomination papers across state lines to mysteriously sign something. I acted in good faith. I followed all of the stuff. I went to every single one of the 784 people who signed this petition. The vast majority of them signed because they believe that everybody has a right to be on the ballot. I believe that's what the judges find in a lot of this substantial compliance case law is that it's very important to not invalidate democracy over clerical errors. I believe this is just simply a clerical error, and I believe the hearing officer got it right in citing that this is simply a clerical error, that this does not open up a case for fraud, and that I should be put on the ballot. Thank you.
All right, thank you, sir. Member McCrory?
Mr. Drew, I appreciate your argument, but as a notary, and people should be a little bit more careful when they're looking at their jurats. On the notary stamp itself, it says state of Illinois. So I'm not sure that I think that becomes fatal to your argument about the jurat. I also think that there is a presumption that when people sign a petition and they put their addresses on there and they say they're from a certain state, that it should be presumed that that is correct unless it is challenged on that specific signature line. So for those reasons, I don't believe that your argument holds water, although it was very good.
Madam Chairman,
Yes, Member Watson.
Counsel, is it your representation that the nominating papers taken as a whole do not cure this deficiency with respect to the jurat?
That is correct, Member Watson. As it relates to that petition, sheets 4 through 92 have neither a state nor a county set forth in there. Now, while the notary stamp says Illinois, the jurisdiction requirement isn't that just that the notary's from Illinois. The jurisdiction requirement is that the signature of the affiant is done in the state of Illinois, where the notary has the jurisdiction to notarize your signature. So by not having a state nor a county in petition sheets 4 through 92, and there's nowhere else to go to see that, the other signatures are on different dates, and therefore I don't think you can automatically assume they were also signed in the exact same place. Had they all been on the same date, I think you might have a better argument to say, well, we can go to these other ones. They were all signed on the same date, and these say they were in the state of Illinois and a county, but these do not. But in this instance, they're signed on different dates. So I don't think we can just automatically presume they were all signed in the same place simply because that's the case. And I think that's the point of the rule being mandatory and the word shall being in it. And that is, when you have shall, it doesn't have to actually show fraud, I believe, in that instance. It's simply that in the future, as we move forward, fraud could certainly take place and there would be no way to know if it happened or not because you're not following the rules that are set out in the word shall.
Thank you.
Thank you.
Well, as a notary, it would be a very big no-no if I signed or notarized something in the state of Missouri for somebody in the state of Illinois. And I would think or hope my fellow notaries would abide by that thought as well.
Well, I think that was gonna be my question is, for the future state of this, how would you ever prove that?
Well, I think that for me, if there was an allegation that a notary was signing outside the state of Illinois, somebody better bring me evidence to prove it to me.
And I think as it relates to that, the question is, how would you ever know when objecting to that? Because if you no longer have to put what state the jurat was done in, and now that's not really a real requirement, what if everyone from here on out just leaves it off? The notary starts signing. I don't know how anyone would ever know at that point the rules become useless. I mean, at that point, they would mean nothing.
Including this, including state of Illinois and county of Cook in your jurat does not preclude you from being a bad actor and going to a different state.
That would be true, but at a minimum, it would be a requirement that you place that on the form and swore to an oath that that is correct.
Member Turbin, please.
Thank you, Madam Chair. If I heard correct from the candidate just a few minutes ago, he said he, when questioned, went and got the notary to file a letter showing that his notarizations were done where he specifically said at one place where's the notary, and he did it in Macon County, and he got the letter and he added it. Is that what you said earlier?
As part of the hearing things, I stipulated in my rebuttal that I would stipulate that these signatures in the Notary Act was performed in Macon County. The hearing officer recommended that I write that up as an affidavit.
Okay.
And so I went there, I had it notarized. I had it notarized by somebody other than Jennifer Steele because I wanted like an independent, a non-party person to go through the process.
Okay.
That would be, I already got a cloud of controversy over one notary public, so I wanted to use another one just to make sure that I affirmed that this was all done. I live in Macon County. Jennifer Steele lives in Macon County. She's registered in Macon County.
Thank you.
And that document was accepted, Marnie, into evidence?
I'm sorry, I missed that.
That the document that the candidate is referencing was accepted into evidence.
Oh, the affidavit, yes.
But to be clear, the affidavit is from the candidate, not from the notary. Just for clarification.
But the notary signed. I mean,
It's
the
a
affidavit.
different, not Miss Steele. It was a different notary.
It's a different notary.
Correct.
All right. Jennifer. All right. Do I have a motion?
So I would suggest a motion to accept the recommendation of the hearing officer and general counsel to deny the motion to strike as moot, to overrule the objection, and to permit certification of the candidate to the ballot as a Republican Party candidate for the office of representative in the General Assembly for the 107th Representative District.
Is
So
there-
moved.
All right, it's
Second.
been moved and seconded. Roll call, Amy.
Ms. Bellicroft,
Yes.
Ms. Craig,
Yes.
Ms. Genovese,
Yes.
Ms. McCrory,
Yes.
Mr. Brett,
Yes.
Ms. Watson,
Present.
Vice Chair Turbin,
Yes.
Chair Donahue.
Yes.
Motion passed.
Thank you very much.
Thank you, Mr.
Thank
Chair.
you.
All right, Marty, next up.
So the next two matters, which are 1C and 1D, involve the same objector and the same counsel. So I would like to hear these cases, 107 and 108 together. However, for fairness, I would give both sides 6 minutes to argue instead of 3 minutes to argue. It looks like Mr. Fogarty doesn't want it.
No.
But maybe Mr. Levitt does. And out of fairness, since we're gonna do these together, we'll give you 6 minutes. So these are Levitt versus McComey, which is 25 SOEB GP 107, and Levitt versus Chesney, 25 SOEB GP 108. I will read my recommendation and the parties can then have their opportunity. So here, both cases concern a certificate of deletions being missing from the nomination papers. And the objector's exceptions to the hearing officer recommendations were filed jointly as one document, which is another reason why, for understanding, I think it's easier to hear the cases together. So here, Objector Levitt objects to the nomination papers of Tony McComey, a candidate for representative in the 89th Representative District in case 107, and in case 108. Andrew Chesney, candidate for senator in the 45th Legislative District. Both candidates, as I mentioned, are represented by Attorney John Fogarty. The objection petitions both allege candidates' nomination papers are deficient because they do not include a certificate of deletions showing any signatures stricken. In both cases, both sides filed dispositive motions. Objector filed a motion for judgment on the pleadings, arguing that the certificate of deletions is a mandatory document to be filed with nomination papers, and that finding substantial compliance here would be an equal protection violation. In response, the candidate argued that Section 8-8 of the Election Code contains directory language, not mandatory language, in requiring a certificate of deletions, and that perfect compliance with technical requirements is not required. In reply, the objector argued that providing no certificate of deletions is non-compliance, not substantial compliance. The candidate filed a motion to strike and dismiss, arguing objector did not sufficiently state his interest in filing the objection as required by Section 10-8. In response, the objector argued his interest is that of a registered voter in the relevant district, which is an issue we talked about ad nauseum yesterday, and the Harding case, HARND. So here the hearing officer recommends objector's motion for judgment on the pleadings be denied in full as portions are beyond the scope of the specific proceeding, raise constitutional issues beyond the authority of the board, and ask the hearing officer to rule on the ultimate legal merits of the case. The hearing officer also recommends denying candidate's motion to strike as objector has sufficiently stated his interest by establishing his status as a registered voter in the political subdivision. There's also a cite to Harned, HARNED versus Evanston Municipal Officers Electoral Board cited on pages 102 and 180 of your packet. On the merits here, the hearing officer recommends finding, and I agree that legislative intent is not furthered by permitting a technical requirement like a certificate of deletions to keep a candidate off the ballot, and finding candidates substantially complied with Section 8-8 of the Election Code. So the objection could be overruled and candidates' names certified to the ballot for the respective General Assembly offices they seek. The objector filed exceptions to the hearing officer's recommendation, arguing it is unfair that candidates can rely on substantial compliance while objectors have to strictly comply with the rules of procedure. In response, I will note that substantial compliance is a judicially created doctrine, holding that even mandatory requirements of the election code do not require strict compliance, as ballot access is an important right not to be lightly denied. The rules of procedure are adopted by the board to ensure that cases are handled expeditiously and resolved in time for ballot certification. Case law mandates that come down from the Illinois Supreme and appellate courts are not similar to the rules that this board passes, and I do not recommend any alterations to the hearing officer's recommendation in light of the exceptions. And with that,
All right.
the objector.
We have Mr. Levitz is in Springfield.
Yes, Mr.
please.
Levitt, Leavitt.
Thank you. Continue.
All right. In light of the rulings yesterday, in case number 538 and the recommendation of the general counsel today in cases 107 and number 108, it looks like democracy is functionally dead in Northwest Illinois. I ran for county board in 2024. There were virtually no challengers on the ballot of any kind. The election was a foregone conclusion before March even came, and by November, everybody knew exactly what the ending of that election was going to be like. So if 4 of you follow the general counsel's recommendation in these cases, it won't be revived. In fact, democracy will be worse off in Northwest Illinois and probably in further rural, sparsely populated counties of Illinois. I'm asking you to avoid setting a very dangerous precedent that will grossly expand what it means when someone like Mr. Fogarty argues substantial compliance. These cases are about a required form being omitted by 3 candidates who rely on a lawyer to keep them in compliance with election law. We are not talking about pro se candidates. I know from the proceedings yesterday that you're capable of feeling empathy and probably wish the laws were different. So if you want legislative change and really feel the kind of empathy that I witnessed here in Springfield yesterday, you need to send a clear message and a clear signal to the legislators that legislative change is long overdue, especially to resuscitate election law in rural counties. If 5 of you can find the courage right now, you can create an earthquake that will be felt in the Capitol building here in Springfield. 5 of you with a vote right now can remove Andrew Chesney and Tony McCombie from the March ballot and force them to run as write-in candidates, just as you have done for Josh Atkinson in case number 538 yesterday. I do not make this request lightly. I did not set out to make this request today, but Illinois has a serious problem and it is getting worse. The legislature might have created the statute, but from what I have seen yesterday and today, it is being used as a weapon. And where I live, it is killing democracy. In cases 107 and 108 and yesterday in 538, Mr. Fogarty's job was to aim your weaponized statute so that it eliminates competitors and protects his clients. But the 8 of you are the ones who pull the trigger. It is your decisions in meetings like this one that are producing disparate outcomes. It's not just the signature requirement statute that is killing democracy. It is that combined with your leniency on every other ruling where the power is in your hands. I get it, believe me, you do not want to be seen as the mean person who turns away somebody who traveled with a service dog 7 hours by car and sat here for 6 hours yesterday, but that is exactly what you did to Sue Cook. Sue Cook probably easily spent over 100 hours working with Josh Atkinson as one of his volunteers to get 1,028 signatures, sufficient to meet the petition requirement. But up in Cook County, you sat in a room with John Fogarty, an experienced lawyer who is representing as many as 15 clients and likely not being paid directly by any single one of them. The technical errors that Sue Cook and the other volunteers made were unforgivable sins in your eyes. But a professional lawyer who has made numerous technical mistakes is given accommodations for every mistake he, as a professional, was very capable of avoiding. I wish you all could see the screen grab that I have on my phone. Within minutes of your ruling yesterday in case number 538, the Stevenson County Republican Central Committee, chaired by Mr. Jogerts, the objector in the case yesterday, posted a celebratory post congratulating Andrew Chesney on eliminating his competition from the ballot in March. They were not celebrating a functional democracy. They were celebrating a broken system that favors the incumbent, and with your help, they won their battle. Who in their right mind celebrates the death of a free and fair election? Volunteers like Sue Cook spent hundreds of hours traveling on 2-lane county roads, getting 1,028 signatures. And Sue is a woman who travels with a service dog to get around independently. She is a serious advocate for policy change, and Josh hears her. Andrew Chesney ignores her. On the flip side, Mr. Fogarty is operating across all three of these cases with a sense of entitlement that is breathtaking. But he knows every action he takes functions outside of the statutes, where he knows that he will be given by the aid of you and your general counsel an accommodation or an opportunity to cure in every instance. And his clients are celebrating today, celebrating a no contest election year again, just like 2024. You are in a position now to derail a Fogarty-fueled celebration and level the playing field. If this technical omission on the part of Mr. Fogarty is forgiven and yet technical requirements for signatures is enforced against Mr. Atkinson, you will have killed Sue Cook's belief in free and fair elections. I know some of it is followed by statute and you can hide behind the statute, but in this case, you could also, 5 of you, could make a difference. Several times yesterday when you kicked somebody off the ballot, I heard you say, better luck next time. But the statute is the statute, you say. Our hands are tied. Do you honestly believe that Sue Cook will ever spend over 100 hours of her time and her own gas money getting signatures again? I know she won't, believe me. Find the courage to do what's right.
Thank you, Mr. Levitt. I don't think we ever said better luck next time. All right, Mr. Fogarty, you have the floor.
Mr. Fogarty, if you don't mind standing by this lovely white piece of paper, please.
Yeah. Thank you. Where do I start on that? Thanks for giving us 6 minutes. I will not take that long. Regardless of Mr. Levitt's diatribe, I would have to say, the simple fact is this. We'll first address what cases are actually in front of you rather than what happened yesterday. 2 candidates in this case. In these cases we're talking about, Tony McCombie running for state rep. She needed 500 signatures to get onto the ballot. She submitted over 1,400 signatures. Andrew Chesney, who needed 1,000, submitted nearly 2,000, right around 2,000, well in excess of the minimum. In both of these cases, the sole argument to keep these candidates from the ballot is that there were petition signatures stricken and not a certificate of deletions that accompanied. In McCombie's case, 3 signatures out of 1,400 were stricken. In Chesney's case, about 9 out of about 2,000. This case is governed by Section 8-8 of the Election Code. And it allows for a certificate of deletions to be submitted. And it provides that a candidate or a circulator who would like to strike signatures may do so by submitting a certificate of deletions. They don't have to. It's not a requirement. It is not a shall. That is the singular objection that Mr. Levitt has brought before you. It's without merit by the plain language of the statute. There has never been a case that has said, if you don't provide a certificate of deletions, your petitions that have almost 3 times the minimum number of signatures are gone. You're bounced. It's completely contrary to law. This is a soapbox for Mr. Levitt, and that is all. He focuses most of his time on the case that occurred yesterday. And as we mentioned yesterday, you very kindly said to certain candidates who just simply didn't get enough signatures, get enough signatures. That's all that is. That's all this is. And I would ask that the recommendation of the hearing officer be accepted. This objection, both objections, be dismissed.
Thank you, Mr. Fogarty. Marty, do you want to?
I think the only other point I would bring up for Mr. Fogarty is the hearing officer chose to rule on the merits rather than on your motion. which is not how I would have done it, but if you're okay with it, I'm okay with it.
Totally fine with that.
Okay, so my recommendation here would be a motion to accept the recommendations of the hearing officer and general counsel in cases 107 and 108. Deny objector's motion for judgment on the pleadings, deny candidate's motion to strike and dismiss, overrule the objection, and certify candidates' names to the ballot.
So moved. Good. There's been a motion and a second. Amy, roll call, please.
Ms. Bellicroft,
Yes.
Ms. Gray,
Yes.
Ms. Genovese,
Yes.
Ms. McCrory,
Yes.
Mr. Brett,
Yes.
Ms. Watson,
Yes.
Vice Chair Turbin,
Yes.
Chair Donahue.
Yes.
Motion passes.
Thank you.
Thank you.
All right,
Might we do a brief break?
you may.
Thank you.
We'll take, what time is it now, ma'am?
It's 10:48.
All right.
Taking the break.
Can we come back at 11?
Thank
All
you.
right. Let's continue and we'll do
Let's
the
make
next up.
sure that Springfield can hear us.
Rick, can you hear us?
We can hear.
All right, let's go. Marnie, you're up.
1G, Williams versus Carrara, 25 SOEB, GP 534. The parties can stand by this white piece of paper, please.
We're
So,
not doing
Mr.
532?
Williams.
Yeah, we.
Oh, I'm sorry, did I skip one?
Jacoba.
Yes.
Oh, I'm sorry about that, and sorry for making you stand up.
32.
There it is. Okay, my apologies.
Yeah.
Jacoba versus Danos, 25 SOEB GP 532. So this is a record examination case, and objector Jacobo, represented by attorney Kevin Morphew, filed an objection to the nomination papers of candidate Danos, who seeks office as a Democratic Party candidate for comptroller. The objection petition alleges signature line objections only, resulting in insufficient signatures. Following a records examination, candidate had 4,343 valid signatures, which is 657 below the statutory minimum of 5,000 signatures under section 7-10. During the Rule 9 motion period, the candidate filed a response to the records examination. The pleading alleged a mathematical extrapolation theory to rehabilitate signatures struck during the records exam, but no Rule 9 evidence was offered to rehabilitate signatures as required by Appendix B to the Rules of Procedure. The objector argued that if the pleading was intended as a Rule 9 motion, it was an improper one. The hearing officer recommends making no changes to the results of the records examination as a result of candidate's response to the records examination, as there's no cognizable basis for relief based on formulas, suppositions, or extrapolation as requested by candidate. I agree with the hearing officer's recommendation to find candidate submitted insufficient signatures to sustain the objection and not certify candidate's name to the ballot as a Democratic Party candidate for the office of comptroller. Now, the candidate did file exceptions to the hearing officer recommendations, arguing that the hearing officer failed to consider his argument under Rule of Procedure 11 that the objector has not carried his burden of proof. He argues that no proof was provided for the results of the records examination, except for the 66 signatures in which the voter was not registered at the address shown. Now, candidate could have attended the records examinations with watchers for each computer if he wanted to view the process of how each decision was reached on every signature ruling, and review the evidence. Additionally, Rule 9G2 provides that the party taking exception is the one who bears the burden of producing evidence, proving that the staff ruling in question was made in error, and candidate here did not do so. So my recommendation is to sustain the objection.
Mr. Morphew?
Good morning, everyone. Kevin Morphew on behalf of the objector. We ask that the hearing officer's recommendation be adopted by them.
We have a motion. So moved. A second? Second. It's been moved and seconded. Amy, roll call, please.
Ms. Bellarcroft,
Yes.
Ms. Cray,
Yes.
Ms. Genovese,
Yes.
Ms. McCrory,
Yes.
Mr. Brett,
Yes.
Ms. Watson,
Yes.
Vice Chair Turbin,
Yes.
Chair Donahue.
Yes.
Motion passes.
Thank
So
you.
much.
Thank you, Kevin.
And I apologize for the false start on Williams versus Carrar 1G, but we'll try it again. It's 25 SOEB GP 534. And sir, you Attorney Sutley?
No, I'm the objector, Williams. I attorney Studley what here to make, so I just stood in place that I was the one started.
Excellent. Thank you, sir.
So you're Mr. Williams.
Yes, ma'am.
Excellent. And for both of you, when we get to you, you'll introduce yourselves and spell your names, although I think hopefully the court reporter knows how to spell Williams. He does. I will read my recommendation and then the objector can speak first and the candidate second. So objector Williams, represented by attorney Michael Sutley, filed an objection to the nomination papers of candidate Carrar, represented by Ross Seckler, and who seeks office as a Democratic Party candidate for the office of Senator in the 34th Legislative District. The objection petition lodged individual signature objections resulting in insufficient signatures, and also alleged that notary Ruba Khalil, R-U-B-A Khalil, Khalil, who notarized 173 of candidates' petition sheets, does not meet the mandatory requirements that the state of Illinois and the Secretary of State application requires. That was the entirety of that portion of the objection. So candidate filed a motion to strike and dismiss the objector's petition, arguing the petition lacks sufficient specificity in stating the nature of the objections as required by section 10-8 as to the notarial allegations. Candidate argued first that the pleading is general reference to a deficiency of a notary's signature under the Secretary of State's Notary Handbook is insufficient to place candidate on notice of the allegedly disqualifying deficiency in notarization. And second, that even if there is a deficiency with the notary's signature, that deficiency should not invalidate the relevant petition sheets under the principle of substantial compliance. The objector responds that the Samuelson case, SAMELSON, which is cited on page 378 of your packet, allows electoral boards to consider new objections if those objections fall within the nature of the objection made, and that the objection sufficiently put candidate on notice that the identified notary failed to comply with the Illinois Notary Public Act's requirements for how notaries are to utilize their signature on certificates. A records examination was held. It determined that candidate had 2,075 valid signatures, which is 1,075 above the statutory minimum of 1,000 signatures under sections 8-8 of the election code. The hearing officer recommends, and I agree, that the motion to strike the notarial allegations should be granted as they are insufficiently pled under section 10-8. Results of the records exam should be adopted, placing candidate far above the minimum signature count, so the objection should be overruled, and the candidate's name should be certified to the ballot as Democratic Party candidate for the office of senator in the 34th legislative district.
Mr. Williams?
That district, I think that's incorrect.
Oh, I'm sorry. Thank you. 14th district. I'm so sorry about that. If Sean can make sure that the district is correct on the order,
So,
that would be great.
so would that help?
Thank you.
Because that mistake was given, the 34th.
Unfortunately, that does not,
So
it helps to make sure your order is complete, but I appreciate the
I was
correction.
just trying,
Thank you for telling me. It's probably just a typo on the sheet.
Yes. That's the reason we're here, because of errors, mistakes, things like that.
But you made a successful point,
Yes,
so
yes, so-
you win.
good.
That aspect.
Thank you very much.
All
I
right,
have nothing to say.
all right. Thank you, Mr. Williams. Mr. Seckler.
With that, we would urge you to accept and adopt the recommendation of the hearing officer and general counsel. Thank you.
All right, do I have a motion?
A motion to accept the recommendation of the general counsel and the hearing officer.
Second. It's been moved and seconded. Roll call, please.
Ms. Bellarcroft,
Yes.
Ms. Craig,
Yes.
Ms. Genovese,
Yes.
Ms. McCrory,
Yes.
Mr. Brett,
Yes.
Ms. Watson,
Yes.
Vice Chair Turbin,
Yes.
Chair Donahue.
Yes.
Motion passes.
Thank you both.
Thank you all.
Great, thank you.
All right, Marty, next up.
And we are up to our final electoral board matter of the day. This is continued from yesterday. It is agenda item 1I, Suitors versus Brown, 25 SOEB GP 570. I believe I saw Max a moment ago.
He just walked out the door.
Okay.
He's here. Go ahead.
Okay. In this matter, the objector is represented by Daniel Olswing and Eric Hendricks, and candidate is represented by Max Solomon. The board heard this case yesterday and determined that under Rule of Procedure 9G3, good cause existed for candidates' delay in providing Rule 9 evidence in the form of 8 certified voter records from the Will County Clerk's Office. The case was continued to provide an opportunity to determine next steps in order to bring this case to a resolution, mindful that today is the statutory deadline for ballot certification. I also needed an opportunity to revise my recommendation to account for the board's good cause determination, permitting consideration of the 8 voter records from the Will County Clerk. So yesterday afternoon, our wonderful board staff, attorneys, conducted a review of the 8 voter records received from the Will County Clerk. The findings of that review were distributed to the parties and to the board early yesterday evening. So in summary, staff recommends that candidates' Rule 9 motion be granted as to 4 additional signatures because registration records show the voters were registered at the address listed on the petition sheets. Staff recommends that the Rule 9 motion be denied as to 4 other signatures. 1, because the address number on the registration record differs from the address number on the petition. 1, because the voter who signed the petition was not registered at the address listed on the petition, and the voters registered at the address listed on the petition are not the voters who signed the petition. 1 signature, because registration records do not show a registration for the individual who signed the petition and do not show a registration for the individual at the address listed on the petition. And finally, 1 signature, because the handwriting signature on the petition sheet do not appear to be a reasonable match to that appearing in the voter registration record. So following the records examination and the Rule 9 hearing conducted by the hearing officer, candidate had a total of 793 valid signatures, which is now, I'm sorry, this is following the first Rule 9 hearing. There was 793 valid signatures, which is 6 signatures below the statutory minimum of 799. But my recommendation here is to determine candidate rehabilitated 4 signatures with Rule 9 evidence from the Will County Clerk, that the Rule 9 motion should be granted as to those 4 signatures and denied as to the 4 remaining signatures. Following the records examination, a Rule 9 hearing, excuse me for 1 second. So long story short, following all of the Rule 9 hearings, the candidate filed 797 valid signatures, which is 2 signatures short of the statutory minimum of 799. Now, candidate's counsel very kindly notified the objector and me last night that he planned to raise paragraph 3 of his exceptions to the recommendation of the hearing officer today. Paragraph 3 challenges 4 specific signature rulings made by the hearing officer at the original Rule 9 hearing. Paragraph 3 reads, and this is in candidate's exceptions. So in addition, the candidate takes exceptions and seeks reversal of the hearing officer's rulings as to exhibits A8, A14, A15, and A16, because the hearing officer's ruling and recommendations are inconsistent with this honorable board's ruling as provided in Appendix B of the Rules of Procedure. Further, the hearing officer's rulings disregard the nature of the objector's objection as clearly stated in the objector's petition, therefore amending the objector's petition. So paragraph 3 does not explain how each exhibit is inconsistent with Appendix B or objector's petition. So I could recommend to disregard the exception for that reason alone, but I will not. Given that the candidate is only 2 signatures from the ballot access, I reviewed in detail all 4 rulings made by the hearing officer, as well as the relevant petition sheets and voter registration records, as did my staff. Please be aware that Rule 9G2 places the burden of proof on the party seeking to prove the original staff ruling was in error, which here is the candidate. So following my review of each hearing officer ruling, I agree with the hearing officer that these 4 signatures were not rehabilitated for the following reasons. So first, as to Exhibit A8, the signer of petition sheet 29 line 5 did not print their name at all. So the candidate provided a certified registration record of a voter named Adam J. Faber, F-A-B-E-R, registered at the address shown on the petition. What candidate failed to prove is that the signer is indeed Adam J. Faber and not some other individual residing at the same address. Candidate did not meet that burden. The burden could have been met through the circulator, through Adam J. Faber himself confirming it was his signature, or by expert testimony that the signature on the registration matches the signature on the petition. And the time to meet that burden was at the Rule 9 hearing, not today before the board. Second, as to Exhibit A14, the signer of petition sheet 98, line 2, who identified himself as Carl, K-A-R-L, Albalar, A-L-B-I-L-L-A-R, listed his address as 1438 Bangor Lane, B-A-N-G-O-R. Now, the candidate provided a certified registration record of Carl Albalar, registered to vote at 1436 Bar Harbor Lane, which is a different street name than Bangor Lane. So the voter record actually demonstrates that the signer was indeed not registered at the address shown. Same thing for Exhibit A15. The signer of petition sheet 98, line 3, identified themselves as Carwyn, Karwynn, Albalar, Albillar, listing their address as 1436 Bangor Lane. Candidate provided a certified registration record of Carwyn Albalar, registered to vote at 1436 Bar Harbor Lane, which again is a different street name than Bangor. So again, the voter registration record determines the signer was indeed not registered at the address shown. And finally, as to Exhibit A16, the signer of petition sheet 100, line 4, who identified herself as Bridget Gannon, listed her address as 4512 Stoneley, Stonely, in Downers Grove. So candidate produced a voter record for Catherine with a C, B Gannon, Gannon, registered at 4512 Stoneley Avenue in Downers Grove. Now, in order to rehabilitate the signature successfully, the candidate would have had to prove that Catherine B. Gannon and Bridget Gannon are the same person. And candidate offered no proof in this regard. And again, the time to meet that burden was at the Rule 9 hearing, not today before the board. To refresh yesterday, on candidate's motion to strike and dismiss objector's petition, my recommendation is to adopt the recommendation of the hearing officer. To first grant the motion to strike objector's nonconformity allegations, finding that the objection petition has no detailed basis, facts, or allegations regarding the format, content, heading, and uniformity of size of the petitions, and to deny the remainder of the motion to strike, finding the remaining allegations within objector's petition are sufficiently pled under section 10-8 of the election code. So on the merits of the objection, given the rulings yesterday by the board finding good cause, I recommend that the objection be sustained because candidate filed 797 valid signatures, which is 2 signatures short of the statutory minimum of 799 required by section 7-10B, and that the name of candidate not be certified to the March 2026 general primary ballot as a Republican Party candidate for the office of representative in Congress for the 11th congressional district.
Thank you, Marnie.
Objector.
Yes, Mr. Vaught, right?
Hendricks.
Hendricks. I'm looking at something else. Mr. Hendricks. Let's don't go into, very brief to things that are new, please.
Sure. So first off, we agree with all of the recommendations in which the staff recommended and the general council's adopted regarding the denial of the 8 late filed Will County subpoenas. Additionally, to supplement that, an additional reason it could be denied for page 4, line 9, it's that the subpoena request was for a Bostnick, and it's a different name than the voter registration that was actually provided, which was Bostnick.
Can you spell those?
Sure. What was requested was for Bostnick, which is as indicated in the staff report, it's last name Bostnick, and then the Will County or the purported Will County voter registration record is Bostick, Bostick. So the name
Bostick versus Bostwick.
I heard the same spelling twice.
Both without an N, same spelling without an N.
There's a Bostnick and a Bostick.
Okay.
Oh, okay.
Which,
thank you.
I apologize. And so that's just an additional reason to deny it. Additionally, page 13, line 2, the voter registration record for Beverly Kangas shows that the status is REM, stands for removed. Obviously, all the others have ACT, which stands for active. She's removed. She should also not be considered a registered voter.
And I'm sorry to interrupt you. If you could spell the voter's name again, the court reporter does not have the sheet that you're referring to.
Sure. Page 13, line 2, which is for Beverly Kangas, Beverly, and then last name Kangas, K-A-N as in Nancy, G-U-S.
All right, thank you, Mr.
And then additionally, as far as the ones that were granted, page 15, line 5, that is for William Hayworth. First name William, W-I-L-L-I-A-M, last name Hayworth, H-A-W-O-R-T-H. The face of it clearly shows that he resides in the 14th Congressional District and therefore is not an eligible signer, and therefore it should be denied, not granted. And then page 65, line 2, it is for Rebecca Shoemaker, which is first name Rebecca, R-E-B-E-C-C-A, last name Shoemaker, S-C-H-U-M-A-K-E-R. That should also, it was recommended to be granted, it should also be denied. The voter registration records provided were for a different name, being Schumacher for the last name, which is first name Rebecca, same spelling, last name Schumacher, S-C-H-U-M-A-C-H-E-R.
All right, thank you, Mr.
And then
Hendricks.
just
You're-
as
you're up.
two more points in 10 seconds. Rule the board's rules 10A2 says that all voter registration records need to be certified. None of these were certified, and therefore I think they should all be denied for that reason. And 10B 10A2 is that rule. Then 10B2 says that the hearing board will not retry matters that were presented to the hearing officer unless the evidence was excluded. Therefore, the additional 4 signatures that the candidate is seeking to remedy, I don't even think should, if we're following the rules, should not be considered by this board, regardless of the recommendation.
All right, thank you, Mr. Solomon.
Thank you, Madam Chair, Board. First, I just want to thank the board for this opportunity. Since yesterday, we appreciated it, the candidate appreciates it. Now, the only thing that I'm going to say as to the recommendation of the general counsel is that here we are, we have a hearing officer who granted our motion because some of the pleadings were not correct. And we filed exceptions stating that the objection, the nature of the objection cited by the objector was not what the hearing officer ruled on. We heard signatures. None of these petitions, none of the signatures had anything to do with signature. At least the candidate was not informed of that. The petition objection was not registered at the address. That's 1. 2, signers are not required to print their name. Signers could just sign. It's an optional.
No, on the form, it does say optional.
It says optional on the form and then the address. What the record examiner would do is look at the signature, pull up the address, see if the signature matches. I challenge respectfully this board and the hearing office and the councils to look at exhibit A14 and A16. Bridget A8 and A16. Bridget B. Gannon, signed Bridget B. Gannon. Catherine B. Gannon signed it, but printed Bridget. And that's why they denied it. Catherine's signature matched the record from Will County, however, from McHenry County, I think. Okay. And she printed B, Bridget. That's the only reason that was denied. And then finally, for Adam, he didn't print his name. He signed, listed his address. You could find his signature at the address, and then we're denied because he didn't print. That's not what the objection said. That was amending his petition at the Rule 9 motion post filing the objection. And those 2 signatures alone, members of the board, puts the candidate on the ballot. And I'm just respectfully requesting that take a look at his signature. Just take a look at exhibit A8 and A16.
May I just make one clarification to something Mr. Hendricks said? I thought under our rule 10A2, if we got records from the county clerk, they were deemed as certified.
That's my understanding of the rule.
Okay, I just to clarify that.
I'm just telling you what the letter of the rule says. The letter of the rule 10A2 says voter registration records must be certified. There's no certification. In other cases I've done, there have been voter certifications. It's completely absent here. There's probably because the names don't match for many of them. and they're just doing their best to get the closest to the address or the closest to the name.
And that was not the objection.
It's
my point exactly.
And actually, just to reply, another 10 seconds. Candidate keeps contending that we're amending our petition or changing what our allegations are. That's not true. What happened was there was a records exam report. The burden was on him. He failed to show that it was that person signing. It's not us. It's not incumbent on us to guess what a scribble is with no printed name next to it. Guess who that is. And then also when it's upheld, for them to present no affidavit, no testimony, anything to say that that's that person. That's not us saying it's a signature. That's him failing to meet his burden to redeem it.
All right, thank you. Do we have discussion? Member Watson, did you want to say something? I heard.
No, I don't want to say anything.
Okay.
Marnie, can you, I mean, just respond to maybe some of the things that, with respect to the signatures and the.
I can't hear you. I can't hear what you're saying.
I asked if our general counsel would just provide any thoughts or insights into the argument with respect to the printed name and the signature of the two in question.
Sure. So before I get to that one, I will say that I do think Mr. Hendricks is correct that the rule says that the board won't relitigate signatures that were already ruled on at the Rule 9 hearing. So Ian might be right there regarding those 4 signatures. But whether you are or whether you're not, this still puts us under. I can say that with respect to Adam, the voter named Adam, who did not print his name, it's true that printing the name is not required, but the signature was a scribble. And we had no idea the name of the voter. And somehow Mr. Solomon found a voter at that address, but it could have been any voter who lived at that address.
The signatures matched.
I didn't think so, but that's not even the point. Not even,
That's not the point. That's not what they raised. They didn't raise signature. I don't know why we're here for signatures.
No,
That's
we're
not
not. I don't think we should be comparing the signatures here.
Right.
But yet again, the point is we didn't know it was Adam. And frankly, we probably shouldn't even be relitigating those signatures. There was a specific one, Hayworth, Haworth, where district was not even objected to. If anyone wants to refresh my recollection on any specific points, there have been a lot of specific points thrown out.
All right, I guess I agree that we should not be relitigating anything that was brought up in the Rule 9 hearing before, period. And if your review of those 4 remaining is your opinion as to you actually looking at those signatures and making a recommendation on that, you are as good as the hearing officer, in my mind. And so therefore, I'm not going to even address those things that should have been addressed in the original Rule 9 hearing, period. So we are dealing now with 4 signatures that you have given your opinion on. Am I correct in saying that?
Yeah.
You have been the one to review. And you have been the one to give your opinion on, based on your review. I take that as proof of what you reviewed, put it that way. So,
Ms. McCarty, we raised the exceptions. It's true, we're not relitigating Rule 9. The purpose of raising exceptions to what the hearing officer, which the board allows us to do, in our motion for exceptions, we did raise these other 4 signatures. We didn't get to them yesterday because we were dealing with the Will County and how the board was going to rule on that. But we did raise them legitimately. We did request that the board review the hearing officer's ruling on that. Council have just done theirs and made a recommendation on theirs, but this board is who we're pleading to or appealing to review these 2 signatures. It's amazing how they're now talking about the signatures don't match when that was not the objection. And the signatures clearly match. That's how county was able to find them.
Mr. Hendricks, just a minute, please. So the 4 signatures are the 2 signatures that we're talking about today, or the 2 lines, voter lines we're talking about today. Are those 2 voter lines that were reviewed by you? Or were they reviewed by the hearing officer back in the rule 9?
The examiner.
Okay, I'm not sure which, there's a lot of 2 lines. I'm not exactly sure which ones you're
A8
referring
and
to.
A16.
Oh, A8 and A16 were reviewed originally by the examiner. And the examiner
Found them to not be valid.
found them to not be valid. I then re-reviewed, I don't know if my re-review is valid or not. but
Correction, not valid, not registered.
Not registered.
It was not signature.
Thank you.
Registered
Not
at
registered.
that address.
Agreed, not registered at address, 100% accurate. I then looked at it again. I agreed with the hearing officer, but I don't know that my agreement with the hearing officer should or should not have any weight, and I'll let the board decide that.
Well, were they registered or not?
Jordan?
They weren't. I mean, look at it.
2 of them were registered at the wrong address.
No, they weren't, the A8 and A16.
Oh, let me
And we're
look
not
at A8 and
arguing
A16.
the others.
You're right, I'm talking about the other 2.
Yes.
One is a guy named Adam.
Faber.
Adam Faber, we found a registration address for him, for somebody, but we don't know if that somebody is Adam Faber.
Because the signature, and we cannot dispute the fact that, or just to deny the fact that the signature, because there was no written name next to it. If you can't distinguish a signature, how do we know that that's Adam Faber?
The county was able to.
Madam Chair, we have someone here that would like to speak.
Oh, George.
If I may, this is Jordan Andrew, Deputy General Counsel for the State Board. I did just want to draw the board's attention to the recommendation of the hearing officer, page 5 and page 8. Sorry, page 7, both of which detailed the hearing officer's examination and evaluation of the arguments proffered by the parties at the Rule 9 hearing on these 2 signatures, the objections, and the candidate's evidence evaluation and argument related to rehabilitating these signatures. The recommendation of the hearing officer appears on pages that I just said. Sorry.
Thank you for that, Jordan. And
So what did the hearing officer say in totality?
Can
Please-
we, those pages? We don't.
And please, I'm sorry, refresh. Mr. Solomon, can you advise which signatures you are referring to here specific with the exhibit number? A5?
A8 and A16, exhibit A8 and A16.
Okay. On A8, the following is what the hearing officer report says. This begins on page 5 of the recommendation of the hearing officer. A8, relating to sheet 29, line 5, the board sustained the objector's objection that signer not registered at address shown. See report at page 9 of 33. Exhibit A8 is a certification from the DuPage clerk related to voter registration information for Adam J. Faber. Candidate testified she personally obtained exhibit A8 from the DuPage clerk. Candidate testified she did not circulate sheet 29 and could not confirm that the signature on line 5 was that of Adam J. Faber. The objector objected to candidate's testimony related to candidate's conversation with the circulator, Brittany, Birttany, Scopa, Scopa, about the identity of the signer on sheet 29, which the hearing officer sustained as improper hearsay. Exhibit A8 was admitted into evidence over objector's objections of foundation, relevance, and the best evidence rule. But the candidate did not meet her burden and established through admissible evidence that the signer on sheet 29, line 5, resides at the address indicated on Exhibit A8. Rule 9 motion denied as to Exhibit A8.
So once the address is established, then that eliminates the the hearing officer's objection with respect to A8?
With respect to A8, the hearing officer found that the candidate did offer evidence that someone is registered at the same address. However, candidate was unable to proffer evidence that the person who is registered and signed this line in petition was indeed the Adam Faber. There is so they proffered evidence that someone is registered at this address. However, the secondary question per the hearing officer's recommendation is that the candidate did not establish her burden of proof that the signer is indeed the person who was shown at that address as presented in Exhibit A8. Therefore, it was the recommendation of the hearing officer that the candidate did not meet her burden to establish that the signer is the person who resides at the address and is registered at the address shown on Exhibit A8.
So once these documents from Will County came in, were they any additional assistance?
This line was not included in those that were presented and determined yesterday.
Okay.
Those that were presented and determined yesterday, there was an additional evaluation done because those Will County exhibits were not heard before the hearing officer. On this A8 and A16 that we will be presumably discussing in a few, the candidate, the evidence was admitted at the Rule 9 hearing. The hearing officer did hear that evidence, argument related thereto, and issued the recommendation that I just read as related to A8, and I can do the same for A16 if the board so wishes. I just want to ensure that we're not conflating the evaluations. The evaluations that were ordered yesterday as a result of the good cause, those were addressed through the staff recommendation that was circulated. These here originating in candidates exceptions paragraph 3, these are exceptions to the hearing officer's recommendations, and those recommendations were made as a result of evidence that was allowed at the Rule 9 hearing. Candidates exceptions is that are though to the hearing officer's interpretation of the evidence and evaluation of the evidence and argument presented already at that
That's
Rule
not my
9 hearing.
argument. That's not my argument. My argument is simply stated is that the hearing officer made a decision on an objection that was not the basis of that object, that was not the objection of the objector. The objector objected only as not registered to vote at that address. The hearing officer ruled clearly, as Councilor said, on signature. We were not there for signature.
Mr. Solomon, how do we prove that somebody who signs a petition that has a squiggle is actually the person that signed the petition, unless we look at that line as a whole to see if they live at that address?
That's correct.
So I reject your argument, and we're not going to
No, I agree with you,
A8 and
actually, but here's what I'm saying. Here's what I'm saying. The signature, whether it's a scribble, whatever how they want to describe it, the signature was what the records examiner looked at. The signature was what the DuPage counter looked at. They found that signature at that address, and they presented a certificate showing, and this certificate has the signature. So the signature is not missing.
I'm not going to go back and
Okay.
re-argue something that a hearing officer vetted very
It was just
carefully.
wrong.
You may think he was wrong, and maybe you have like to stand on, but we don't have that information in front of us. And if we do, it has been re-reviewed and has been confirmed that the hearing officer was correct. So you can argue A8 and A16 all day long, but that is not why we're here. We gave you an extension, everybody, an extension to look at the Will County records. That's what we were brought back here today to do. We're not relitigating everything else. We're not opening it all back up again. We're looking at Will County, period.
We took exceptions in our motion. We're not saying reopen it. The purpose of raising an exception is for the board to review what the hearing officer did, just like I can take this to
Which is
court.
what we did yesterday.
No, we
and
didn't do it on, we didn't get to this yesterday.
Wait a minute.
I don't disagree with you, but the reason for the hearing today is to look at the Will County signatures.
And here are exceptions.
And we have heard them, but what I'm saying, and maybe my fellow board members have a different opinion, is I'm not going to go back and perform surgery on the record examination that the hearing officer did at this point.
Madam Chair,
Yes, ma'am.
if I could, Madam General Counsel,
Yes.
were all of the exceptions, I want this to be clear for the record, were all of the exceptions heretofore filed by the candidate heard as requested by the candidate? Were they heard? All of the exceptions?
Yesterday. That's your question, were they heard yesterday?
Yes.
Yesterday, my recommendation was that.
No, I didn't ask you what your recommendation was. I asked you if all of his exceptions were heard.
I made a recommendation to deny all exceptions. And then Mr. Solomon, I can't recall whether he
They were not
addressed
heard.
this particular
were not
So the
exception.
record should reflect that they were not all heard.
They were not heard.
All right,
A8
fine.
and A16 were not.
Just make sure that the record reflects that. So if we didn't do our job, then it's on the record. They weren't heard.
Well, they were heard today.
I was just gonna say, well, I think we have the
Well, they
opportunity.
can't be heard today.
We've already heard
Well,
them.
we just heard one. I was gonna say, I don't believe that we heard a 16. So I think
And
that
14 and 15, actually, 4 of them. We raised A8, 14, 15, 16, and all we want is for the board to take a look at them. Unbelievable how this year actually.
I have 3 minutes, so please.
Okay, I apologize.
Thank you. Jordan, can you please read A16 for us?
Yes. A16 appears in paragraph 9, which crosses pages 7 and 8 of the hearing officer's finding and recommendations. It reads as follows. A16 relating to sheet 100, line 4. The board sustained the objector's objection that signer is not registered at the address shown. See report at page 22 of 33. Exhibit A16 is a certification from the DuPage clerk related to voter registration information for Catherine B. Gannon, who resides at 4512 Stanley Avenue in Downers Grove, Illinois. Sheet 100, line 4, contains the printed name of Bridget Gannon, who purports to reside at that same address. The candidate did not provide any testimony that established that signer Bridget Gannon was the same person as Catherine B. Gannon on Exhibit A16. Exhibit A16 was admitted into evidence over objector's objections of foundation, relevance, and best evidence rule. The candidate failed to meet her burden in overturning the board's ruling to establish that the signer was registered at the address shown on sheet 100, line 4. Ruling. Rule 9 motion denied as to Exhibit A16 and sheet 100, line 4. And again, this is the evaluation that was offered in the recommendation of the hearing officer following the conduct of the Rule 9 hearing.
Excuse me, can I have a spelling on Bridget Gammon, please?
Yes, it is Catherine, it's Catherine, Catherine, Gannon, G as in girl, A, N as in Nancy, N as in Nancy, O, N as in Nancy. And then the Bridget Gannon is BRIDG as in girl, ET as in Tom.
Except that it's I won't accuse anybody of lying. It's a lie, Your Honors, Board. If you look at the petition, Catherine signed Catherine B. Gannon. That's the signature. But this hearing officer, for some reason, looked at the written in the middle, the optional. The signature was there. The written was there. The address was there. Catherine signed Catherine B. Gannon. The signature matched. But Catherine wrote Bree Gannon in the optional. And then this hearing officer says, no, this is not the same person. First of all, we were not there for the signature. The signature and the address match according to DuPage, but this hearing officer just stuck to Bridget.
All right, that's enough.
I mean, what other two lines were raised in your exceptions?
So this one will be A18, Bridget Gannon,
Understood.
A16, Bridget will be A16. And all I'm asking, look at it, look at the petition. They have it.
That's what I was gonna ask is, Marnie, did you, and apologies, but I just need clarity. Did you look at this one? And that's where I said, and what is your response to the fact that it appears that the issue is with the optional printed name not matching and not the signature and the address?
Okay, I would want to pull the petition back up because I did this at like midnight last night and I want to refresh my recollection on it unless Jordan knows the answer off the top of her head.
I have it. You have it.
I do not, but if you would allow me, I will get the original objection. Nope, the original petition from my office.
Thank you, Jordan, because if Jordan doesn't mind doing that, she's number one, better and more experienced at it, and number two, I can handle any other questions while Jordan does that.
And on favor too. Both those are the two that we're raising.
And Jordan, did you hear favor?
A16.
Just to be clear, are you only raising it on 2?
Well, actually, we are here for A8, 14, 15, 16. But the one that is incredibly unbelievable to us is A8 and A16. Now, we can argue on A14 and A15 just to be on the record. Both addresses were actually on the petition, just for the record. Bangor Lane and Bar Harbor are both written by this signer on the petition. Now, granted, Bar Harbor Lane looked like it has a line across it. And the objector didn't object to that. We have Bar Harbor, we have Bangor. Signer, the circulator stated that those two streets were the same. Bangor is Bar Harbor. That was a testimony. You can check the records. That was a testimony. But this hearing officer decided to go with Bangor. Ignore Bar Harbor. We have a DuPage County certificate that shows Bar Harbor. It's there on the petition, but we're not even raising that. We're not camping on that. We're camping strongly on Bridget, Catherine, and Adam. Those were unbelievable.
Yeah, comment.
And if you get those two, you guys are on the ballot.
We're on the ballot, yes, ma'am.
We need a resolution, Marnie, with respect to those two.
Well, it's actually one.
So
I
first
think
off,
we need to take a vote on them first.
so first off,
Jordan is back. Jordan is back here.
All right, Jordan,
Hello.
continue, Jordan.
Please, I believe it was member Ballard Croft who asked the question. If you could repeat that
Yes.
question for me.
Dan.
So we don't have it before us. So what I'm asking is, does this hinge on a printed name not matching, strike that. Is the signature and the address, do they match?
And this is on Bridget versus Catherine.
Okay, so I'm looking at sheet 100, line 4. The first column is the voter signature. That appears to be a C.B. Gannon. The next column is voter's printed name, which is optional, but the voter did print a name, and the printed name is Bridget Gannon. The street number in the third column, or excuse me, the street address in the third column is 4512 Stanley. The next column, city, town, or village, is Downers Grove, Illinois. The final column says DuPage. So and again, I don't want to engage in a supposition on what this is hinged on and what it has not hinged on. I will say that the hearing officer identified his analysis as stating that this line does contain the printed name of Bridget Gannon, who purports to reside at the same address. The candidate did not provide any testimony that established that signer Bridget Gannon was the same person as Catherine B. Gannon on the exhibit A16. If you would like my opinion on it, happy to give it.
Yes.
But
I would
only-
like
You're looking at it.
Thank you. What we have here is a voter registration that gave us Catherine B. Gannon. The signature line, looking only at the line, is a CB Gannon. The printed name, which the voter offered, is Bridget Gannon. The voter registration record that was given to us is a Catherine B. Gannon. Now, my personal opinion, while it is very reasonable that folks go by their middle name over their first name, the evidence that has been proffered, as identified by the hearing officer, is that we do not have identification on the record that the B in Catherine B. Gannon that is on the voter registration record is Bridget. This information, as the hearing officer has stated, could have been provided, and that the candidate did not meet her burden in overruling the determination at the record exam level that this was not the same person, and that Bridget C.B. Gannon, Bridget Gannon, is the person whose voter registration record appeared in our database. And that voter registration record, based on my reading of the hearing officer's report and recommendation here, shows a C.B. Gannon at 4512 Stanley Avenue.
So my question is, because the printed name is optional, if you did not have a printed name of Bridget Gannon, which is like, would we be here?
My position is no, because it's CB Gannon. You'd have no identification of the first name or last name. And that's assuming that that's your interpretation of the signature to begin with.
You didn't object to that. That was not your objection.
We objected, to be clear, we objected to the voter does not reside at that address. If there is an illegible, and by the way, it was upheld by the records examiner, the hearing officer, the recommendation of the general counsel so far. Okay. Now, what I will say is it is now at that point shifted to you to present evidence that it is that person's signature, which you utterly failed to do, and which the hearing officer pointed out. You are asking the board to essentially violate Rule 10b2 in essentially relitigating things that you failed to do at the hearing.
If you had advised that you had a problem with the signature in your petition, we would have responded.
We couldn't tell who it was.
Stop it. Stop it.
I have a question. Would it have been appropriate, and is there an argument to be made that if the hearing officer decided that he did not agree, right, with those lines on the petition, right, and rejected them, to rehabilitate those lines, would it have been appropriate for Mr. Solomon and the candidate to submit affidavits from those two people who signed those lines saying, yes, in fact, I am who they say I am, and yes, in fact, that is my signature? Would that have been appropriate action?
That's not the objection.
How is it not the objection?
The
You have
objection-
to rehabilitate a signature.
The affidavit, in that case, the affidavit from Bridget would have been, I'm registered to vote, because that was the objection. I am registered to vote at this address, and here is my voter's registration. And we provided the voter's registration. The question that this board is not asking, that we're praying for this board to ask, is to see the signatures. The CB Gannon, it's exactly the same as
That's not our
it
job.
is.
That's not the point.
To answer Member McCrory's question, without delving too far into the appropriateness or the inappropriateness, it seems to be what the hearing officer found missing in his analysis of this is any sort of evidence that demonstrates that C.B. Gannon and Bridget Gannon are the same. That could have been cured, as you suggested, through an affidavit from Ms. Gannon, presuming it is the same person that says, yes, I am Catherine B. Gannon. The B stands for Bridget. This is who I am. I'm registered to vote at this address. Here too are the voter registration records that support that. It could have been, as the hearing officer notes, proven up by the testimony of the circulator of this petition sheet, which appears to be Larissa Calviness. Pardon my any mispronunciation that is there. It for the hearing officer that, or for the court reporter, that appears to be Larissa Lavanese. But again, it was the hearing officer's recommendation in reviewing all of the information that was presented that candidate did not meet her burden to overrule the determination at the record exam level by whatever avenue was available to her.
What was the original objection?
The objection at this is that the signer is not registered at the address shown. And the signer here is a C.B. Gannon with 4512 Stanley, Downers Grove, Illinois. And the optional printed name column that appears filled out says Bridget Gannon.
All right, any more questions, Member Watson?
No, I just want to make sure that the original objection was, I just wanted to make sure what it was. So CB, whoever it is, Gannon, according to the objector, did not live at the address shown.
Registered.
Or registered at the address shown. And the documents that we now have show that someone named who?
Catherine B. Gannon.
So Catherine B. Gannon.
Bridget, and it was spelled out in the document, Catherine Bridget Gannon.
So on the voter registration record, it says Catherine B. Gannon.
Is it B or Bridget? B.
It says B.
B.
So Catherine B. Gannon lives at the address shown.
Yes.
But C.B. Gannon doesn't live at the address shown, was what the hearing officer came up with. Is that correct?
Bridget.
Madam General Counsel.
If I may, Member Watson.
No, I don't want, Jordan. C.B. Gannon does not live at the address shown. Is that the determination of the hearing officer? Is that the determination?
Is this for me? The
Yes.
determination of the hearing officer is that candidate failed to meet her burden to overturn the board's ruling that the signer is not registered at the address shown.
So C.B. Gannon is not registered at the address shown. And the documents that we have show that Catherine B. Gannon is registered at the address shown. Is that correct? Do the documents that we have now show that Catherine B. Gannon is registered at the address shown?
The documents that were provided by candidate show a voter registration record for a Catherine B. Gannon at 4512 Stanley Avenue in Downers Grove.
Thank you.
All right, anything to final, Marnie?
I just want to
Anything
make
with Kate.
sure, I there's an objection as to whether those 4 signatures that I reviewed even can be rehabilitated. So the record should reflect that. But otherwise, it's up to the chair whether she wants to hear more argument.
No, do we have, a motion to
I'm not
resolve
sure what
this?
the appropriate motion would be, but I think they're asking us to decide whether or not these 4 signatures should be rehabilitated. If you ask me,
So I think the motion could be simple, and I'm sorry, I didn't mean to cut you off. I apologize.
go ahead.
I mean,
Good microphone.
yep,
Would you speak up, please?
yep, I'm gonna speak into the microphone. I think that the appropriate motion, because we've been a lot of places, would be, well, at least from my perspective, would be to deny the recommendations of the hearing officer and certify the candidate find that the candidate has 5 additional signatures. 6, sorry, additional signatures.
I don't believe that that's the.
It's, you certified 4, correct? You said 4 after your review. You found 4. Is that correct?
I agreed with the hearing officer that 4 were not properly rehabilitated, which left us at 2 signatures short of the statutory minimum of $7.99.
Okay, so out of those 4.
Right.
Let's compartmentalize
So,
it.
yeah.
Out of those 4 signatures that were not rehabilitated, you are arguing in favor of rehabilitating all 4.
That's correct.
Okay. I reject the rehabilitation of the 1 signature of Adam Faber. I'm just saying that right now. I reject
I
that.
think
Say that again.
members of the board, what would probably be very helpful in making this recommendation is if you could distinguish the signatures that are at issue. Unfortunately, here we're in a situation where both categories of signatures have 4 signatures at issue. So the first group of signatures that would be rehabilitated are those signatures that are recommended to be rehabilitated as a result of the staff review conducted.
Thank you,
based-
George.
Yeah, so first, based on
That's right.
the recommendations of the staff review pursuant to the board's finding of good cause.
And those are the
As
Will
I-
County documents.
Those
And
are the
that's
Will
what
County
discussed
documents
below.
Yes.
as
Okay.
identified by paragraph 2 of candidates' exceptions to the recommendation of the hearing officer. That's the first group. There were 8 there. The recommendation is to grant their motion as to 4 of those 8. And then the conversation that we have been engaged in today, that includes Mr. Faber, Member McCrory, as well as Ms. Gannon, all of these are identified in candidates' exceptions to the recommendation of the hearing officer, paragraph 3. So if
2 different motions.
2 motions.
we've got 2 motions. I think we need a motion on paragraph 2, which would be the recommendation is to grant as to 4, deny as to 4.
I like that.
And then,
Second.
Second. Yeah.
okay,
We have a roll call on this?
We have to do 2 motions.
So yeah, there's gonna have to be 2 motions. Jordan, can you restate your motion, your suggested motion, since we can't make motion?
the suggested motion would be to adopt the recommendation of the staff review of the Will County documents, which are candidates' Rule 9 evidence.
Just so for my clarity, my understanding was no matter what happened today, that if there were signatures on the 8 Wills County subpoena issues, that I would be granted equal time. So are we making a final ruling today?
So here is the issue with that we identified last night, is that you didn't file a Rule 9 hearing.
Oh, my God.
Rule nine motion.
They didn't file anything, no. This is essentially his rule, not, or his, not his.
Yeah, our 9 rule.
We have a motion on the floor.
His,
Yes.
his
Hold
acceptance.
it. Zip.
Mr. Hendricks.
We have a motion we have a motion on the floor. So Amy,
So this motion is limited only to the
County.
Bell County documents, correct? Okay.
all right.
It is to the staff recommendation on the Will County documents identified in candidates exceptions, paragraph 2.
Amy, roll call.
Tell me who made the motion and who seconded it.
The motion was made by, member McCrory and seconded by Jennifer Ballard Cox.
Thank you. Okay. Ms. Delacroix,
Yes.
Ms. Craig,
Yes.
Mr. Nevezi,
Yes.
Ms. McCory,
Yes.
Mr. Brett,
Yes.
Ms. Watson,
Yes.
Vice Chair Turbin,
Yes.
Chair Donahue.
Yes.
Motion passed.
Okay, now, so the current status. The issue that has been discussed in detail today originates in candidates' exceptions to the recommendation of the hearing officer, paragraph 3. Paragraph 3 are those 4 signatures identified by Marnie in her recommendation that she made today. Marnie, if you could just, for clarity's sake, re-identify what those are.
Absolutely. So in exception number 3, the candidate raised issues that were determined by the hearing officer under Exhibit A8, A14, A15, and A16. And it was the recommendation of both the hearing officer and myself that those signatures were not rehabilitated.
And just for clarification, A8 was Adam Fader.
Yeah, A8 is Adam Faber.
Faber.
2 and 3 are the folks who aren't sure if they live on Bangor Lane or Bar Harbor Lane. And then A16 is Bridget and or Catherine Gannon.
Gordon?
So I would presume then the motion would be to adopt the recommendations of the general counsel and hearing officer as it relates to those, no, strike that, sorry. At this point, the recommendation, I think, from the board would be either to grant or deny, or to accept or reject the arguments proffered by candidates' exceptions to the recommendation of the hearing officer as identified in paragraph 3.
Or a variation thereof.
Yes.
I have one question, Madam Chair.
Go ahead, Madam Member Watson.
So we've heard, and somebody correct me if I'm wrong. Have we heard anything today about 14 and 15, or have we only heard 8A and 16?
The 14 and 15 is about Bar Harbor versus Bangor.
Oh, okay, all right.
Okay, Jennifer.
All right, my question for clarification from our general counsel is just we've had a lot of good discussion today. And that discussion occurred after your recommendation. Do you right now, as we're preparing to vote, still stand by your recommendation to deny these 4?
The only one that I'm wavering on is Bridget Gannon. But I think that people should know which street they live on, and therefore I'm not really buying the rehabilitation.
Or in Downers Grove.
Yeah.
As far as I can tell on Downers
No.
Grove. That wasn't the information.
That's
But if you,
my hold up.
you have to think about it as a whole. If you can't read a signature, and there is nobody printed a name next to it. How do we know that that signature actually belongs to that person who lives at that address?
If-
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 if
if
it's
it's-
re-
if-
if-
Wait.
This is between
As-
us now.
As one, two, Andy, as there's four of us here that have actually done this. I know when I did it, and that's what I want to clarify. We had a set of rules and we went to training before every time we did it, for every election. And I could have swore, and I could be wrong because it was years ago, that we had this as an example. If you only had the address and couldn't read the name, how to either sustain or deny. I could have swore that was in our training. Is that still there? Bernadette, could you please
Yes.
elaborate?
So, if there is an address that can clearly be discerned, however, for the name, whether it's a signature or it's printed, it's what we would consider unintelligible, undiscernible. It's a scribble. We can't make out letters, anything like that. If you look up the registration and you go through who's registered there, if you see a name and there's a signature clip that matches that, like that's how a person signs their name, great, because we know that that's a person and that's their signature. So we would overrule that objection, count the signature. But if you look through, say you do find records, you look through each individual, there is nothing similar to what is on that sheet in the form of signature. We would sustain that. We would give notice to the party and say, as I think the hearing officer did here appropriately, if you are arguing that that scribble is this person, but there really isn't anything reasonable matching in the record, please bring them in for testimony or provide an affidavit so that I feel comfortable saying that is not just a random, scribble that that person didn't actually sign. Because unfortunately, if you don't do that, you could have somebody just write addresses all down a column, because candidates are allowed, circulators are allowed to do that, and just scribble. And if those were to all count, how are we really ensuring that voters are putting their individual signature
I
there?
appreciate that. I just want to clarify, so that in this case, the hearing officer then found that the scribble did not match the voter registration signature.
No.
Jordan, can you weigh
What
on that?
was the objection? What was the objection? Was the objection to the signature?
Registered
You don't have to
address.
get to talk, you don't get-
Between us, guys, not you, you're done.
The objection was that the signer is not registered at the address.
And that's where the court is gonna go first.
Yes.
Every reviewing court is going there first. What was the objection?
Yes.
So what we're saying here though is, yes, it's registration, but as part of that question is who is the signer?
Right. You cannot
Mhm.
separate them.
So is it Adam Faber or is it Adam Faber's wife?
Right.
This or Johnson.
Or
Look
no-
at it.
Or John Smith
Yeah.
or,
Look
you
at
know.
it.
Need to look at
That's
it. The
not a
hearing
job.
officer has already looked at it.
He didn't.
Yes, he did.
It's-
All right,
You did.
are we ready? Do I have a
All
motion?
right, so are we voting to rehabilitate one or two or four signatures?
None.
I can make a motion.
That's
Okay,
the
and
way-
if we could try to
We can,
identify the numbers 8 is Adam, 14 and 15 are the folks on Banger Lane, and 16 is Gannon.
Yes.
So if we can try and identify which exhibit we're trying to rehabilitate, that'd be great.
I would make a motion to reject the rehabilitation on A8, A14, and A15, and to grant the rehabilitation on A16.
I'll second that. It has been moved and seconded. Roll call, Amy.
Ms. Malakoff,
No.
Ms. Craig,
Yes.
Ms. Genovese,
Yes.
Ms. McCrory,
Yes.
Mr. Brett,
Yes.
Ms. Watson,
No.
Vice Chair Turman,
Yes.
Chair Donahue.
Yes.
Motion passes.
Okay, well,
So just for those keeping track of the math, at this point now, as a result of the two board motions and in accepting the recommendation, candidate is one signature short.
You know, I hope that this case goes up on judicial review.
We are.
Because it's heartbreaking and
Well, this is the thing, I did exactly what Bernadette said.
I understand.
Bernadette just.
Yeah, but we still need to do.
Bernadette
I'm sorry,
just,
ma'am.
Bernadette just explained exactly what I did. I went to DuPage County, showed them my petition sheets. Do you know I went to 8 counties to make sure this was done? She just explained to everyone in here what the procedure was. I did that procedure, exactly what she said. They matched that name. I wasn't the circulator on there. So with that being said, thank you, Mr. Bernadette, for actually bringing that up so it could be for the record. Because this is exactly what I did, what I was told to do.
And for the record, may we make a motion to reconsider the board?
Mr. Solomon, I think
Hold
we
on,
have
we haven't
vetted
finished
this.
the motions
Sit
yet.
down.
No, I'm just
I think
filing
that you
like a
will
motion
vote.
in court for reconsideration.
We haven't finished ruling on the objection yet.
Oh,
So I think we need to finish ruling on the objection before you would
sorry.
do that.
And
So-
can I just say first, though, we have vetted this 6 ways from Sunday. We have taken a lot of time on this.
Oh, no. And
no one
I
has taken
really
this petition
appreciate that.
lightly.
100%. Please understand that my gratitude is of statute, but I would not waste time. Your time, my money, his time, your time, if I didn't know for sure what I did as a candidate to make sure that I know that I had 799 signatures. That's the thing. If I did not, I'm not a person that wastes people's time.
And what I
That's-
used to say as a prosecutor, what I know and what I can prove are 2 different
And
things.
that I showed you guys the proven record from what Bernadette explained to each one of you guys on this board out of her own mouth, that if you cannot see a signature, that you can go to each county, give them the address, and if the address matches a signature that is on there, I wouldn't have never taken Adam Faber. I had to pay for that. That was not free to me. So why would I take and pay for a person's information that I can't do anything with? The only reason why I took it is because the signatures matched. And Marnie, I'm sorry if that's your name, she went over it. We went over this several times last night, because if that was not the case, I wouldn't be standing here today. He would have withdrew me. So the signatures actually matched. Those signatures match, which was not the actual objection.
And that was not the objection.
So I think we've made the record clear. I think we need to now make the ultimate motion, which is.
Right, and then parties have, you both, it's very clearly, stated your arguments, so I don't know that it's even proper to consider what I reviewed last night, but we'll find out when the court tells us. So for now, based on the motions that this board has taken, the motion would be that the objection be sustained because candidate filed 798 valid signatures, which is 1 signature short of the statutory minimum of 799 required by section 7-10B, and that the name of candidate not be certified to the ballot. And that.
If I may, Marnie, we would also need to include an order on the disposition of the motion to strike and dismiss, which as the hearing officer and you have recommended is to grant in part and deny in part.
Thank you. Add that.
Thank you, Jordan.
You're welcome.
Do I have that motion?
So the motion is 1 signature under plus motion is granted in part, denied in part.
So moved.
Is there a second?
Second. Been moved and seconded. Amy, roll call, please.
Are you second to that?
Chris.
Ms. Delacroix,
Present.
Ms. Craig,
Yes.
Mr. Evasi,
Yes.
Ms. McCory,
Yes.
Mr. Brett,
Yes.
Ms. Watson,
Present.
Vice Chair Turbin,
Yes.
Chair Donahue.
Yes.
Motion passes.
All right. Now, where are we?
Thank you.
Other business. Other business
We get it.
before the electoral board. Do I have comments from the general public? Anything down there in Springfield, Amy? General comments from the general public?
None in Springfield.
All right, none here. So, can I have a motion to recess the state officers electoral board until Wednesday, February 18th at 10 a.m.
So moved.
Second.
Amy, roll call, please.
Ms. Bella Croft,
Yes.
Ms. Cray,
Yes.
Ms. Genovese,
Yes.
Ms. McCrory,
Yes.
Mr. Brett,
Yes.
Ms. Watson,
Yes.
Vice Chair Turbin,
Yes.
Chair Donahue.
Yes.
Motion passes.
All right. Now we will reconvene as
Take
the
a breath.
State Board of Elections and have a roll call, Amy.
Ms. Bella Croft,
Present?
Ms. Cray,
Present.
Ms. Genovese,
Yes.
Ms. McCrory,
Here.
Mr. Brett, Ms. Watson,
Yes, present.
Vice Chair Turbin,
Yes.
Chair Donahue.
Yes. All right. Reported the general counsel.
Okay, I will make this as fast as I can, and thank you, campaign disclosure parties, for waiting through that very long thing.
Yes, we're sorry.
We really appreciate it, but obviously this was a really big deal. So I have 3 appearances on file. I'm going to call for settlement offers. And I will call those folks who are actually here first. So agenda item 4A2, Friends of Bert Girl, 24 NF 72. Is Mr. Girl here? Or someone on behalf of Mr. Girl?
I think
In
Mr.
Springfield.
Earl may be in Springfield. Are you in Springfield? Yes, he is.
I am.
There he is. Okay, sir, I am gonna read my recommendation and then you'll have the opportunity to comment to the board. So the committee here is offering $3,250, which is 50%, to settle $6,500 in penalties for late filing of 6 quarterly reports. The committee was administratively terminated in February 2025 after not filing reports since June 2023, but they have since filed their delinquent reports. The committee's current fine balance is $6,500, but the candidate should be aware there are still $4,500 in fines yet to be assessed for the late March, June, and September 2025 quarterly report. So the settlement today would only cover the $6,500. It would not cover the the $4,500 for the March, June, and September 2025 quarterly reports. So considering the settlement factors and Rule 125.450, I recommend accepting the offer as it is compliant in terms of balance and receipt ratios. The committee is offering 50% of the fine balance, and the committee is low dollar with an average ending balance and most recent balance of $143.14. And to avoid ballot forfeiture for the March general primary, this fine must be paid today.
And that fine doesn't affect the 45 that could be coming, or the forfeiture
Yeah,
doesn't have any effect on
the
that.
ballot forfeiture is not affected by any penalties that have not yet been assessed. So if the offer is $3,250, and if the board accepts that $3,250, and if Mr. Girl pays the $3,250 today, there is no ballot forfeiture.
Did you hear all that, Mr. Girl? Do you have any comments?
I did hear that. The only comment I would have is that at this present moment, on this particular day, I have actually no funds to pay that. I would ask for leniency to a reasonable amount of time, say 15 business days, to make the $3,250 payment.
Under any other circumstances, I would say yes, but today is the ballot forfeiture date. And Article 9 very clearly states that all fines must have been paid by the ballot forfeiture date.
So if you don't pay today, then you forfeit the ballot.
Marnie, if I could just interject, and this is Tom
If I'm
Newman.
wrong, Tom, please correct me.
Yeah, Tom Newman, Director of Campaign Disclosure. Since Mr. Girl would be running at the local level, the certification date for that is January 14th.
Yay!
So you would have until the 14th to pay.
Okay.
Thank you, Tom, for being my
Thank you.
hero. Mr. Girl, can you get it in by the 14th?
I will try my absolute hardest, and if I don't, I think it would just be because my derelictions that I would be stripped. I think that is fair and just.
Well, that's nice.
Thank you,
We
Tom,
need
for
some
saving
good
the
news
day.
today. Okay, all right. So do I have a motion?
I will make a motion to accept the $32.50 and have it paid by the 14th.
Second.
Second.
Roll call, please.
Ms. Ballard Croft,
Yes.
Ms. Craig,
Yes.
Mr. Nevezi,
Yes.
Ms. McCory,
Yes.
Mr. Brett,
Yes.
Ms. Watson,
Yes.
Vice Chair Turbin,
Yes.
Chair Donahue.
Yes.
Motion passes.
Thank you.
All right,
Good
now
luck.
we're gonna
Thank you.
go to
Appreciate
Friends of Lamont.
Yes, so next we have an appearance for A4 Friends of Lamont Williams, 24 DQ 106. Mr. Williams is up here in Chicago. The committee is offering $1,100 to settle $7,200 in fines for late filing of 4 A1s during the fourth quarter of 2024, as well as the December 2024 quarterly report. Considering the settlement factors in Rule 125.40, I recommend accepting the offer as the committee is low dollar with an average ending balance of $2,762.08, and the committee is offering more than half its current balance of $2,104.58. So the recommendation is accept.
I have a question. It says on our average ending balance, $12,221 and an average total receipts is $5,189.
So I actually caught errors in that settlement offer sheet and had Tom and Andy correct it. It's looking like maybe the corrected one that I didn't make it into the packet. But Tom, can you confirm that?
Oh, he's speaking with.
I don't see it.
Oh,
He's speaking with,
Mr. Newman is not in the room. He's speaking with the
Gotcha.
candidate from the previous matter.
I did this. I personally checked the balance on our website. And the balance on the website based off the most recent quarterly report was $2,104.58. So I 100% verified that.
Just want to confirm the
All right.
discrepancy.
Do I have a motion?
I make a motion to accept the settlement offer.
Second. It's been moved and seconded. Amy, roll call, please.
Ms. Ballard Croft,
Yes.
Ms. Craig,
Yes.
Ms. Genovese,
Yes.
Ms. McCory,
Yes.
Mr. Brett,
Yes.
Ms. Watson,
Yes.
Vice Chair Turbin,
Yes.
Chair Donahue.
Yes.
Motion passes.
Thank you. And I would assume if you're on the ballot, get the check in ASAP.
Oh, no.
Okay.
I was just trying to get this settled because it's been.
Oh, okay. All right.
Thank you. All right, I have one more appearance on these cases. It's 4A5 Citizens for Kimberly Haley. 25 AM 59. Madam, are you Mrs. Haley? Yes, sir, Ms. Haley. If you could stand by that little white dot to take the suspense out, I would recommend accepting the offer if you increased it by $130 to $2,630, which is half of your current balance. So are you willing to increase the offer by $130?
Yes.
Okay, then I recommend accepting the offer.
So moved.
Second.
It's been moved and seconded. Roll call, please.
Ms. Ballard Croft,
Yes.
Ms. Craig,
Yes.
Ms. Genovese,
Yes.
Ms. McCory,
Yes.
Mr. Brett,
Yes.
Ms. Watson,
Yes.
Vice Chair Turbin,
Yes.
Chair Donahue.
Yes.
Motion passes.
Thank you for coming in. Sorry you had to wait through all that.
And the payment that.
Andy can help you.
Perfect, thank you.
All right.
So there's two remaining cases, 4A1 and 4A3, just confirming there's no one here in Springfield.
No one in Springfield.
Perfect, the recommendation is to accept both settlement offers for 4A1 and 4A3.
All right. It's been moved and seconded. Amy, roll call, please.
Ms. Ballard Croft,
Yes.
Ms. Craig,
Yes.
Ms. Genovese,
Yes.
Ms. McCory,
Yes.
Mr. Brett,
Yes.
Ms. Watson,
Yes.
Vice Chair Turbin,
Yes.
Chair Donahue.
Yes.
Motion passes.
All right, now we have information on the potential ballot forfeiture.
We do, but we have a couple of candidates who have paid their fines this morning.
Okay.
So if you want, we can try and list all of their names, but Tom will make sure that those individuals who paid this morning are taken off the list and ensure that they make it on the ballot. So would you like to hear the names?
Oh, okay, so
Would you? I'm asking.
I don't need you.
I don't need to because of
Okay.
the simple reason that I would,
Okay, well, wait, thank you for the folks that paid today and congratulations about making it on the ballot.
I also just wanted to note that Tom has been reaching out to people on this list
so let them
kind of
know.
continuously to let them know and to try to notice it up. So thanks to Tom for doing that. And also hopefully then we do get more payment in, especially for any of the candidates that we are supposed to certify.
And what is the deadline for those payments?
If we're the certified
Today, right?
ballots today, close of business, if it is like a county, a local level, it's the
14th.
Right, so if we get payments for a state office or above by 5 o'clock today, that would be fine for them to be on the ballot. If they are a local candidate, then it would be the 14th.
The 14th, and Tom will make sure that anyone who pays between right now and either the end of the day or the 14th, whichever is relevant, are removed from this list.
We accept that. All right, do I have a motion to accept?
We don't need to make a motion. That
Oh,
was
I'm
just-
sorry.
Yeah, I
we
wanted
needed
to make sure you
Okay.
knew that that there were some good folks who paid, so I wanted to give them credit where credit is due.
Then number 7, 4A7.
And that is just a list of the good folks who paid their civil penalty assessments as of the time this was given. And of course, as we mentioned before, some others have paid since.
Well, Marnie, you're done.
Thank you.
Until executive session.
Amy,
We'll do that next.
I would think we need to do something. Can we approve the ballot?
That's actually.
Oh, so, thank you, Marnie, for everything.
No
It's been through the holidays. It's been a lot, we know, and it takes your staff and everybody, but
Thank you.
we do.
And Jordan and Sean and Leah,
Yes.
we've midnights and weekends and the whole business. So thank you.
I think I also just want to say, this has been, these 2 days, we've had really challenging things. I think it's been the most challenging cases that I've seen in my time. And I think that it has been handled really well by all parties, but Marnie, like, thank you for your leadership on that. But
Thank
I
you.
think all of my members as well. I think that we did a good job. So.
Yeah, right. A lot of brain work and a lot.
All right, so let's keep going and move with Bernadette and the executive director.
Excuse me, can you turn that microphone so it's pointed at you?
This one?
Yes, please.
Yeah. Good. Okay. Yes, so good afternoon. This is the point where I, in a sense, get to take a little bit of credit for all of Marnie's work, all of your work the last 2 days, last 2 months, and the staff's work for the last 3 months, even before then, preparing for candidate filing. So I want to echo your sentiments to thank legal staff, like first, but also all the staff here. All those record exams we did, we had so many objections, so many record exams. Literally everybody on staff helps with record exams or processing the petitions, the objections, covering phones for those that are checking signatures. So it was a massive effort. It was done very well too. On time, I think you all received materials to review well ahead of the meetings, which really helps with disposing of the cases and everyone being knowledgeable to do so. So very successful overall. This is a really good point in the meeting. It's sad that we don't always have as many people here as we do when we're going through the cases, but congratulations to you. I will now ask for a motion from the board for the certification. So with regard to certification of the ballot for the March 17th, 2026 general primary election, staff are seeking a board motion to certify the ballot as finalized today and to authorize staff to issue amended certifications as appropriate in the event of 3 circumstances. 1, rulings in matters relating to pending electoral boards and or judicial reviews or other litigation in the courts. 2, removal of candidates on the ballot forfeiture list if their fines are not paid by the deadlines we just discussed. and 3 candidate withdrawals. And the withdrawal deadline is today, but this is any withdrawals received after today, subject to confirmation that affected election authorities can implement those withdrawals without incurring burdensome reprinting and reprogramming costs for the ballots. So that is the motion we are seeking, and thank you.
Do I have a motion?
So moved. Second.
It's been moved and seconded. Amy, roll call, please.
Ms. Bellarcroft,
Yes.
Ms. Craig,
Yes.
Ms. Genovese,
Yes.
Ms. McCrory,
Yes.
Mr. Brett,
Yes.
Ms. Watson,
Yes.
Vice Chair Turbin,
Yes.
Chair Donahue.
Yes.
Motion passes.
Okay, thank you. I'm going to circulate a signature sheet for the members here. Amy will do so to the member Turbin in Springfield, and then we'll also adhere and affix electronic signatures for those members that are virtual today.
Sounds good. So the other information from our executive director is basically informational with the voting systems testing. Unless we want to do are we going to do a legislative report? I know.
I just have a very brief update.
Okay.
Just wanted you all to know that we did file our budget with the General Assembly timely. We are working on ISLs. I know the legislative subcommittee has asked to see those in the past, so once those are drafted and finalized, we will get you a copy of them. Other than that, we have worked with LRB on just initial draft language that supports the legislative agenda that the board previously approved. We're seeking sponsorship for those legislative items. Already, we're monitoring election-related bills or language. We will keep everyone updated throughout the next few months, and more particularly legislative subcommittee as important priority items come up. It is the start of session. We expect it to be busy on all fronts, but particularly we'll keep you updated on the board's agenda as well as the budget and the hearings that will be happening in the spring.
That's good. Did you want to make your point? No, that's in here. Okay, all right. Sorry. So then, is there any other business?
Everything else provided is the routine informational items, just for your review. If there's any questions, either now or as board members are reviewing ahead of next meeting, if there's anything you would like an update on or clarification, we're here, but no further formal action needed from the board.
That's good. Do we have any other business then? Are there comments from the general public? Amy, do you have anyone down there?
None in Springfield.
All right, Andy? All
I
right.
am gonna have a couple things for executive session now.
Yeah, okay, no, we've got that to go. All right, we will now, I would request a motion to go into executive session for the purpose of discussing pending litigation in the minutes of the December 9th meeting, our executive session pursuant to sections 2C11 and 2C21 of the Opens Meeting Act, 5 ILCS 120. So moved. So, Mr. Hendricks, you have to, roll call, please. You have to exit.
Ms. Bellarcroft,
Yes.
Ms. Craig,
Yeah.
Ms. Genovese,
Yes.
Ms. McCrory,
Yes.
Mr. Brett,
Yes.
Ms. Watson,
Yeah.
Vice Chair Turbin,
Yes.
Chair Donahue.
Yes.
Motion